Okay. Maybe. Okay. Item 8, there is a reply. Item 8. Okay.
Wait, please, Your Lordship. My lord, I like to mention for listing for today, my lord. Very urgent matter, my lord. Tomorrow, whatever, my lord, the petitioner hearing is a governing body, my lord, which is performing as per the direction of the Honorable Court, my lord. And this petition is still pending. Now, my lord, its constituting body has called a meeting tomorrow, my lord, to take a decision on the my lord, governing body. So tomorrow is the meeting, my lord. So matter can be taken at 2, my lord. It has already been numbered, my lord. Oblige me.
Okay. You have 40? I have 40 lead petitioner opposite party. Okay, on request made by Mr. AK Hussain. Then count 40. Public. Okay. List the matter after 3 weeks. 3 weeks.
May I please? I like to mention for listing, my lord, I for implement of party, my lord, which is, my lord, in item number 72 of supplementary list.
Item?
72, my lord.
Oh.
In that case, my lord, I have filed an implement petition, my lord.
Okay.
That may be not a list on next Thursday. I'm for the petition, my lord. Here, matter pertains to, my lord, promotion to the post of in-charge headmaster, my lord. There is a order from the director of.
Item 72?
Yes, ma'am.
Okay, your good name, please.
I'm A guy, my lord.
And the counsel for the petition. Mr.
K. Kolita.
K. Kolita, the counsel submits that he has filed an IA for implement of party in connection with the said petition. Accordingly, the registry is directed to release this matter along with the connected IA or
Thursday, my lord.
when?
On Thursday, 19.
17. Not
Much obliged, my lord.
may consider the matter that I think item number 35. I am for the petition. Maybe taken up by your doctor. On request made by Arthur. The counsel is after 3 weeks. Okay, 37, 38, 39. On request made by Govind. And 40? Same one.
Item number 4 may be acted. Item number 4, my
Why?
lord. I am physically with my junior. This is not along with me. With my junior, he is at Kolkata. He is also. I am also from my lord.
Okay. Item?
My lord, 4.
Your good name?
Yes, that's my lord.
On request made by Esther. After 3 weeks.
May I please, your lordship? Lordship, I pray for listing of a writ petition, lordship, for motion on Monday, lordship.
Why? What is the urgency?
Lordship, the petitioner applied for the post of a principal in a college. He has eligible and qualified, but screening committee rejected. He was not listed his name, and interview to be held on 17th Monday, lordship, 19th.
Okay.
Obliged. May it please your lordship, I beg to pray before listing the matter by Monday, lordship. Lordship,
What is the urgency that you all want on Monday?
lordship, my MA degree has already been invalidated by the authority, and the present principal incumbent has already been retained by this month, lordship, and the similar judgment already been passed by this court already on.
Okay, not Monday, Tuesday. Thursday.
Deeply obliged, lordship.
Made with lordship. I'm praying for adjournment of item number 57, lordship.
Yeah.
This matter, lordship, yesterday the respondent opposite party petitioner has filed one petition for implement that is not on record. So maybe taken up after vacation.
What is it?
Lordship, My prayer is that I shall file one objection or rejoinder to their objection, Lordship. So I need some time for that.
Okay, then on request made by R. Sharma,
Yes, Lordship.
Learn counsel for the applicant.
For the applicant.
Please the matter after 3 weeks.
Lordship, can it be some fixed date on some fixed
I'm
date?
not fixing date. You are fixing the other.
There is an interim order, my lord, operating.
Interim order passed in the writ petition
Writ petition, my
to continue. You
I'm-
make a mention in the new year.
lordship. I'm deeply obliged.
It is the Lordship. Lordship, may I pray for listing of a motion matter in any date in the next week?
May I, Lordship, I beg to mention item number 41 and 42. Both this matter become infractions, Lordship. Be allowed to withdraw, Lordship.
41 and 42.
Yes, Lordship.
They have complied with the order.
Lordship.
They have complied with the order.
Yes, Lordship.
Okay, Mr.
As you Ahmed.
S.U. Ahmed, learned counsel for the petitioner submits that the respondents have complied with the directions passed by this court. Stop. Who appears on the other side?
To 41,
Item 41.
42. Yudas G. Shaikia, A. Burma. What is senior counsel, Mr. D. Shaikia, Lordship. Kau dia.
You have
Your Lordship, I am appearing on behalf of SMT 60.
Okay.
It is a contempt matter, Your Lordship.
MS
SMT
P
60 name may be recorded.
okay. Mr. SMT learned counsel appears to the respond number
Respondent
All the rest.
1 and 2.
1 and 2.
Yes.
1 and 2. Under 15 about to
Alright.
42 also same.
Same, Lordship. Matter.
Deeply obliged.
Lordship, pray for listing, Lordship, on Monday. We want to withdraw this petition, Lordship.
But Monday make it fish.
Yes,
Yes.
Lordship.
Item 59 for withdrawal.
What
I
is
may be allowed to do the petition with the liberty to file a fresh
Why?
because need some modification law to the
Mr. K. Majumdar learned counsel for pray for withdrawal of the petition with liberty to file a petition. Health Department,
I'll inform law.
Mr.
Gogoi lordship.
B. Gogoi learned standing counsel appears for the health department. With liberty as
Much obliged.
Item 1 for motion. Item 1.
non-appeal. List after 3 weeks.
Item 2.
May please your lordship. Matter relates to provincialization, non-provincialization of the petitioner. And over here, my lord, there are allegations against the departmental officer. So at this stage, notice may go, my lord.
But they have been the EU Chama learned standing counsel secretary. Okay. You are going for
For respondent number 1.
three, four. What? And the state level scrutiny fee cycle of that it appears for respondents 2 and 5. Extra copy.
I'm for the 1, 3 and 4 month.
Petitioner to take steps for service of it's
My lord, I'm sorry to say, my lord, I think my friend will go for 2. Your lordship may give a chance to me to give the correct address, because I think number 2 is the wrong addressing, my lord. I'm sorry, my lord.
that you'll have to file an IA for
Yes.
correction later on.
No, I can, if your lordship permits, then correction of the cause title can be submitted, my lord, with respect of the parties.
Which one?
About respond number 2 and respond number 2 and respond number 6. I'll file a correct. I have to just.
You'll have to make an application for correction of.
Negative. Negative. Negative.
Then I'll withhold the notice for the time being.
Yes.
Next week we'll take up.
Yes.
Okay, cancel the order. Mr. J. Abidin, let the council. Praise for 2 days time
Yes.
to file an appropriate application for correction of the address of the respondent 2 and 6.
6.
Praise the Lord. This matter again on 18. 18.
10th.
1-8.
Yes, madam. My lord, instead of 2 days, 3 days on.
3 days.
Item 3.
May I please, your lordship? But on the last dated, my lord, High order dated 25/9/24, my lord. The petitioner was directed to file additional affidavit, my lord.
Yes. Have you filed your affidavit?
Yes, my lord, I have filed, but the provincialization order of the respondent number 8 is not annexed, as it was not furnished to the petitioner, my lord. I have applied for the said copy before the concerned authority, my lord. I have annexed the application also, my lord, here in my additional
Where's
affidavit.
your additional affidavit? When did you file it?
I have filed it on 3rd of December, my lord. My lord, but I have obtained actually data, my lord, wherein actually the petitioner, the respondent number 8 had joined in service
Okay.
on 11/9/93, my
your
lord. A. Rashid, my lord.
Mr. Rochit, let me call. The petitioner filed it on 3rd of December. Registered to verify and let matter. Verify and let matter. It's the matter on 17th.
My lord, my press notice may be issued, my lord.
Let us see the affidavit.
I have extra copy, my lord. Can it be seen, my lord?
I pass orders.
Item 5.
Lordship, very sorry to mention that I could not reach the court in time because of traffic jam. Lordship, one matter the agency is there, Lordship, for listing was on Wednesday, Lordship.
What are the?
Also regarding salary, Lordship, and Wednesday, Lordship. 18th, deep level.
Have you got instruction?
No, madam. I haven't received any instruction.
None appears for the which is thus the Sunday Council hired praise for 2 weeks time to enable them to receive instruction. Praise the Lord, this 2 weeks. Into motor pass period.
May I please your lordship? Lordship, in this matter, in response to an advertisement, the petitioner was interviewed for the post of assistant professor in Mongolder College, lordship. And the petitioner was expecting his selection, but from a reliable source, the petitioner came to know that the selection committee has placed the petitioner as second nominee, lordship.
Where's the advertisement?
The advertisement, lordship, it was in page 19, lordship.
Yeah. For which post?
Lordship,
Which post do you apply?
for assistant professor in Arabic department, unreserved.
In Arabic,
Yes,
unreserved.
yes, lordship.
Okay.
Then the respondent number 5 fortunately obtained MOBC certificate for age relaxation of 3 years.
Respondent number?
5
Okay.
was selected by the selection committee.
Where's that? Where's that select list?
The MOBC certificate is in page 24, lordship, caste certificate, but he originally belongs to Maimal community, general category.
No, but this is for unreserved category, isn't it? Arabic. One post.
No, he has already crossed the age limit, and according to a condition that is mentioned in
No,
the
this
advertisement.
post of assistant professor in Mangaldoy College.
Yes, yes, lordship.
For Arabic.
Yes, lordship.
That is for the unreserved category only, one post.
Yes, lordship.
Then?
No, in the advertisement, lordship, in page 19, it is written as age should not be more than 38 years as on 1/1/2022. But the respondent number 5 has already crossed the age limit.
Okay.
And he forcefully obtained that caste certificate.
Where's the caste certificate?
Okay, so page 24, lordship.
Then?
He's from general category, lordship. He forcefully obtained it.
Where's the select list?
Then after that, the petitioner filed an application, lordship, before the DHE regarding authenticity of the MOBC certificate and age of the respondent number 5. In addition to that, the petitioner also filed a RTI application, lordship, before the DHE seeking certain information regarding caste certificate, educational qualification documents, and birth certificate of the respondent number 5. That was not provided to him, lordship. And then again, he filed an application, filed an appeal, and after receiving the said appeal, the DHE transferred the same to the respondent number 4, lordship, and with a direction to furnish the information directly to the petitioner, but till then no action has been taken.
Oh, I don't understand. What do you want me to do? The advertisement
Yes, lordship.
for the post of assistant professor
Yes,
in
Congo.
Arabic is for UR, unreserved category.
Yes, one post. But the petitioner was not selected. He is selected as second nominee.
Okay, who was selected?
Respondent number 5,
Where is that? Where is that?
Amir Hussain.
One implement application is
Amir Hussain.
Where can I find the select list?
hello from the pleadings follow it seems that the director is yet to take a decision.
That's why I'm.
And hello
See,
regarding
I don't understand. The post of assistant professor Arabic is for the user
Unreserved
category only.
yes madam.
No other person can be appointed there, correct?
Yes madam. Unreserved category.
Unreserved category.
Yes madam.
Now respond number 5 is claiming to be MOBC.
Yes,
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 ma'am.
Lordship.
Correct.
Yes,
ma'am.
Lordship.
Can he be appointed there?
No. That has to be unreserved category.
It has
This
to
is
be,
one question I'm asking you.
Yes, ma'am.
So when the matter is placed before the director,
Yes, ma'am.
director will take a final decision.
Final decision, ma'am.
Let a final decision come.
notice.
Maybe
will be-
that I cannot issue no. It is purely on apprehension. Nothing has happened. Maybe the director will reject that.
Reject that.
You approach this court after you have a cause of action.
Lordship, he has also crossed the age limit.
I know.
That will be considered.
He
by
has
the-
crossed the. You are saying that you respond number 5 is a general category,
Yes, yes, Lord.
but since he has crossed the age limit, he obtained that MOBC
Yes,
certificate
court.
so that his age can be relaxed.
Yes,
Correct.
yes, yes, Lordship.
But can the respondent number 5 be appointed in the unreserved category?
No, he cannot.
Yeah. Number 2, decision is yet to be taken by the director.
Yes, Lordship.
Where is your cause of action? I'll tell you one thing. You withdraw this. When you have a cause of action, you approach.
Okay, Lord.
All right. MS
He Thaklari.
V.
Thaklari.
Appellate. Oh, that's good. Okay. With liberty. It's done. Nothing to appeal.
Much older.
With liberty.
7,
No problem.
May it please your lordships. My lord, as regards regularization of assistant high school teachers, the division bench of this court, my lord, pursuant to policy decision of the government, where government proposed to regularize, my lord, eligible teachers in batches, a judgment was delivered, and the operative, we are concerned about the last portion of the judgment. It is still holding the field and it is being followed by different single judges. At page 32, 33 of the judgment. Judgment starts at page 31, lordship. Judgment, it is about regularization, page 31. Jivan Deka and others. Then lordship may come to paragraph 3. The respondent states that file affidavit with a prayer to treat the same as reflecting common stand in all cases. State has not unmindful of the plight of the drop teachers. Claims over so-and-so teachers have been adjusted against regular posts. Such norms and policy guidelines introduced from time to time. Then it says, my lord, the state in the affidavit file has enclosed policy document dated 11/3/2003, which has now been introduced to cover the cases of the drop teachers. Such cases will be dealt with by the state in accordance with the said policy, and all those who are found to be eligible will be regularized in a phased manner. Then come below, my lord, 5. There were certain directions then to prepare select list of the for regularization, paragraph 5. Then go to the next page, lordship. Last Roman 6, page 33.
Yeah.
Page 33. All appointed, we are concerned with this clause. All appointments made would be prospective, but will carry the benefit of past services for the purpose of computation of pensionary benefits. Our case will be confined to this. Now, my lord, a series of writ petitions were filed thereafter from time to time, and various minor learned single judges endorsed the same. Then, pursuant to all direction, batches of assistant teachers were continued to be regularized. So far as the petitioners of this petition is concerned, my lord, most of us were regularized way back in 2008. We have given a chart, my lord, which a lordship will find at page 34.
30?
34.
Okay.
We are 13 petitioners in this case. Page 34. Here, my lord, lordship may have a note. the names of the petitioners, then date of appointment. My lord, these are the initial appointments prior to our regularization, continuous service. Then the date of regularization. Lordship will find that most of them were in the year 2008. So also in the next page. Few of them have meanwhile been retired. So apparently, my lord, the new pension scheme came into being in 2011. Therefore, the division bench case and all those cases which were following the division bench said that compute the past services for the purpose of fixing pension. That means earlier 69 pension rules will apply. Now here, my lord, NPS scheme was not even there in 2008 on the date when we were regularized. At that time, it was the old pension rules. So which govern the pension benefits? Then, my lord, as per the mandate of the judgment, it is where, my lord, the state said about implementation, about applying old pension rules and new pension rules. It is where, my lord, the state respondents have made an absolute mess, and hence this petition. Pursuant to Gibbon's case, also another case your lordship will find at page 50-51, Dilip Medhi, it was endorsed. They should be entitled to old pension rules. 50. Lordship may go to paragraph 19, page 50. In view of the fact that judgment order dated so-and-so has attained finality, division bench order, and it has been directed in the direction 6 that all appointments made would be prospective but will carry the benefit of past services for the purpose of computation of pensionary benefits. I find that petitioner service should be counted as per the Assam pension rules and the 69, and the benefit of past service should be counted for the purpose of computation. Accordingly, the respondents are directed to count the benefits under the old rules. Now, my lord, state went on and filed a review against this, which was dismissed. I have annexed, my lord. Then, my lord, review is, my lord, that lordship will find at page 89. Yes, page 89, last portion. Yeah. So review is dismissed. So that means it has already attained a finality, as my lord in subsequent cases also said. Now, my lord, thereafter the government resorted to a pick and choose policy practice in, my lord, regularizing assistant teachers in batches. Kindly have a turn to, which is discriminatory and violation of Article 14 and 16. Have a look at lordship, my lord, kindly, at page 90. This is one such order. So these are various teachers. Pursuant to so-and-so, 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 2-3 cases. The past services of the following assistant teachers are hereby allowed for counting pensionary benefits only as per 69 rules. Then yet another order, my lord. Lordship will find page 94, similar order. This was of 2018. Then lordship kindly turn to another order of 2018, page 96. Page 97, lordship. This is the latest order of April 2024, page 97, lordship. Here, lordship, kindly see these 7 teachers were given the benefit of, my lord, old pension rules, and kindly see the period of past service, last column, allowed for counting pensionary benefits. All of them were regularized in 2011. And as I have shown, in all 30 of these petitioners, my lord, they were regularized in 2008, I have shown. So this is the discrimination and picking and choosing they are doing, my lord. Therefore, my lord, they have put us in a hurry. Therefore, my prayer at this stage will be, we have been representing, I am annexed. My prayer is, it is absolutely discriminatory. You are picking and choosing persons, eligible teachers. Lordship may issue a notice. Observe that pendency shall not be barred to compute, my lord, retirement pension benefits under the scheme.
You are now, are you being considered under the NPS?
My lord, sir, we are under the NPS scheme. That's why I have added a prayer interim. Contribution from every month's salary is deducted. Lordship may stop that as an interim prayer.
That will consider under the.
Anyway, Lordship may at least say, after issuing notice, making it returnable, that pendency shall not be barred to calculate.
Learned Senior Council assisted by MS
And they.
and they Learned Council for the. Issue notice.
I think my learned friend will accept notice for.
Mr. B. Cycle and the document. Appears for the respondent number 1. Chief Secretary, you are appearing, right? MSP Downs, Learned Standing Council Secretary Education appears for respondent 2 and 3. And Mr. R. Babujari, Learned Standing Council Finance appears for the respondent 4. However, it's up for para pendency of this authority apart respond to
For pendency shall not be barred for computing, my lord. Lordship may observe that.
So I'm saying for
Extra.
Lordship,
pendency of this petition shall not be a bar for the respondent to consider your case.
compute, my lord, to compute, my lord,
We'll see what that will.
compute pension benefit. Lordship, that will do.
Item 8.
Fixed coil only. Okay. After 4 weeks, can a date be given, my lord?
It will come after.
Some of them-
Many cases will, you can make a, you can make a mention.
Lordship. 2, 3 of them have retired.
May I please, Your Lordship? My lord, this is the medical admission to PG course, my lord. And in fact, your lordship directed while passing the impugn order, my lord, interim order to, my lord, complete the exchange of pleadings, my lord. Pleadings is complete. My learned friend has filed the affidavit in opposition, my lord, on behalf of Director of Medical Education. And we have also replied, my lord, to the same. And having regard to the urgency, my lord, your lordship was pleased not to issue notice, and thereafter, my lord, take up this matter for disposal today. My. So, my lord, in brief, my lord, while on the last occasion, while your lordship passing the interim order, was pleased, my lord, to keep one seat against, my lord, the state health quota, my lord, vacant in the Department of Radio Diagnosis, my lord, in the Silchar Medical College. Now, my lord, they have taken a stand, my lord, in the affidavit, my lord, in opposition.
Who's the affidavit?
Yes. Now, before coming to the
Affidavit at page 55, my lord.
my lord, before coming to the affidavit, my lord, may I briefly state the facts what has happened to recapitulate, my lord, very briefly. But in fact, the petitioner, she completed the MBBS, my lord, in 2017, and thereafter, as per the compulsory requirement of rural posting, she had undergone it, my lord, from 9th April 2018 to 8 April 2019. She has successfully completed the same, and to this, my lord, effect, competent authority has already issued a certificate, which is Annexer 2. Thereafter, my lord, what happened? My lord, she was appointed as a medical and health officer under the government of Assam in the Department of, my lord, Health and Family Welfare on 23/10/2019. It is Annexer 3, my lord. And pursuant to such, my lord, the petitioner joined on 31/10/2019. Thereafter, my lord, the petitioner is continuing as medical and health officer grade 1 from 31/10/2019. And on, my lord, 1/11/24, she has completed the, my lord, period of 5 years. And in respect of, my lord, the experience, 1 year experience and 5 years experience, my lord, 2 certificates I have annexed, Annexer 2, my lord, and Annexer 3. Thereafter, my lord, what happened? My lord, notice was issued by the National Board of Examination, central government, for holding the, my lord, various examinations, my lord, including my lord, NEET PG 24. And the date, my lord, for schedule was, my lord, to be held on 3/3/24. Eventually, my lord, by subsequent notifications, the, my lord, date was rescheduled, and eventually, my lord, the examination was held, my lord, in the month of, my lord, August. And precisely the date is, my lord, 11/8/24. And, my lord, the admit card was applied, my lord, admit card was issued. And thereafter, my lord, she was successful. She came out successful in the NEET PG 2024. Now, your lordship is aware, out of the total seats, my lord, 50% seats are reserved for the state. And out of those 50%, 40 number of seats in terms of the rule, my lord, are reserved for state health service quota. And after, my lord, the merit list are prepared, my lord, the All India merit list, the, my lord, state, my lord, the district director of medical education, it prepares a separate list, revised state list, my lord. And the petitioner, my lord, she was able to figure in the, my lord, revised state list of Assam. And that your lordship will find at page 38. My lord, the serial number is 401. The name of the petitioner is Jennifer Kaifi Ahmed, general category. And, my lord, it is the quota of SHQ. So the, my lord, doctors who are serving under the state government, they claim, my lord, service under this quota, state health service quota. And the seat is allotted, my lord, against MD radio diagnosis, my lord, in the Silchar Medical College. Now, this is the, my lord, select list, part of the select list, my lord. And page 36, my lord, this is the admission notice. Now, those who are, my lord, selected in terms of the select list, the date for, my lord, document verification, my lord, is indicated herein, my lord. And this notice, my lord, has been issued pursuant to first counseling, my lord. So after the first counseling, she secured, my lord, this seat. And the date on which, my lord, the document verification was fixed was 29/11. Now on 29/11, my lord, when they appeared before the Director of Medical Education Assam, she was informed, my lord, that her, my lord, admission is refused. And immediately, my lord, the seat was cancelled. We immediately approached, my lord, this honorable court. Your lordship, my lord, by the interim order, was pleased to keep, my lord, one seat vacant. Now, the stand taken by them, my lord, is that I don't have, my lord, a continuous, my lord, 5 years period of service, my lord. So basically, this is the stand. I'll come to that, my lord. Before that, my lord, I take your lordship to the relevant rules, my lord. Only 2 provisions of the rule is relevant. The rule is, my lord, Medical College of Assam, Regulation of Admission into Postgraduate Degree and Diploma Course Rule 2021. My lord, it starts from page 39. And the relevant rule, your lordship will kindly come to page, my lord, 42. This is rule 7, 1, my lord, and the relevant rule is 7(1)C, SHQ seat. This is state health quota seats, my lord. Now this reads as follows, my lord. 40 seats, 37 degree 3 diploma, out of total state quota seats shall be reserved in each session for the doctors appointed in the state health service on regular basis on the recommendation of the APSC, MHRB, and who have completed 5 years or more service in rural area. So lordship will, my lord, kindly mark this. The qualification in terms of this rule is that the doctors who are, my lord, appointed under the state health service, my lord, and working under the state government, my lord, the requirement is 5 years or more service in rural area. However, for counting the experience of 5 years of service in rural areas, period of work under so and so, these are, my lord, other, my lord, work under regulation 3F of APSC, the service under any society agency created by the state government or NHM shall also be counted. So these services provided in other, my lord, areas also, that will be counted. And the, my lord, second part is the applicant must complete the required period of service in rural areas on or before 31st May of the year of admission. So, my lord, the cutoff date is prescribed as 31st May, my lord, of the year of the admission. And a certificate to this effect shall be submitted in the format at Appendix 3 along with the application form for postgraduate counseling. Seat metrics, these are, my lord, not relevant. So, under the, my lord, 21 rules, my lord, the requirement is one must have 5 years, minimum 5 years or more service in rural areas. Basically, my lord, this is the requirement, the qualification. Now, what has happened, my lord? The rule-making authority, my lord, had amended the rule, which your lordship will find at page 52, annexure 14. And your lordship will mark, my lord, the date on which, my lord, this has come into force. My lord, subsection 2 of, or sub-rule 2 of rule 1 says, they shall come into force from the date of their publication in the official gazette. So, my lord, the official gazette, my lord, is of 13 March 24. So, this is, my lord, from this date, my lord, the rule has been made applicable. Now, what is the amendment? Is, my lord, in the proviso. Amendment of Rule 7. Your lordship will come to, my lord, the proviso. Provided that state quota seat shall be reserved in each session for the doctors appointed in the state health service on regular basis on the recommendation of the Assam Public Service Commission or Medical and Health Recruitment Board, and who have completed 5 years or more than 5 years of continuous service. So therefore, my lord, this element of continuous service has been brought in. And your lordship will also take note of the requirement of rural service has been excluded. Because it says only, my lord, 5 years or more than 5 years of continuous service. Rural service, my lord, is no more. When a candidate, he has a credit, my lord, to his her credit, minimum 5 years of continuous service, my lord, he becomes eligible. So therefore, my lord, by this amendment, the element of continuous service has been brought in. Now, my lord, what the, my lord, respondent wants to, my lord, contend that while examination of the scrutiny of the documents, my lord, it was found that the petitioner, to her credit, my lord, did not have a 5 years continuous service, my lord. So therefore, my lord, that was, my lord, rejected. Now, here I take your lordship, my lord, to the affidavit, what have been contended by the, my lord, medical education, director of medical education. Your lordship, my lord, I'll take only to the relevant para. I think, my lord, para 8 is relevant. So I need to draw your lordship's attention to para 8. Page 57, my lord, of the counter affidavit filed by the director of medical education, my lord. May I read it, my lord? That as regards the statements made in para 18 of the petition, your deponent states that the National Board of Examination published information bulletin for admission to MD, MS, PG diploma course for 24-25 session, inter alia notifying the following important dates. Online submission 16/4 to 6/5/24, issue of admit card 18/6/24, examination date 23/6/24, declaration of result 15/7/24. Subsequently, the Medical Counseling Committee, Government of India, had published the Postgraduate Counseling 24 schedule and All India Quota and State Schedule PG 2024 on 1st November 24 in its website for commencement of online counseling and admission for postgraduate courses 2024. The Medical Colleges of Assam, Rule 21, Amendment 24, was notified by notification dated 13/3/24, and the same was published in the official gazette on 13/3/24. Since the new amended rule has come into force with effect from 30/3/24, i.e., prior to the last date of submission of application with effect from 16/4/24. Hence, the Medical College of Assam Regulation Admission into Postgraduate Degree and Diploma Course Rule 21, amended 2024, is applicable for the candidates who has participated in the counseling process for admission into postgraduate courses in the Medical College of Assam for the session 24-25. It is further stated that an educational notice was issued by the answering respondent on 14/11/24, wherein it is also specifically stated that the first round counseling for admission into 50% postgraduate seat in the Government Medical Colleges of Assam and BBCI Guwahati under Assam State Quota for session 24 will be held as per Medical Colleges of Assam Regulation Admission into Postgraduate Degree and Diploma Course 21, amended up to date. Subsequently, an admission notice was published on 26/11/24, inter alia stipulating that all admissions shall be provisional and will be subject to fulfillment of all the requisite eligibility criteria as per the Medical Colleges of Assam Regulation Rule 2021, amended up to date. The petitioner participated in the admission and counseling process in terms of the education notice dated 14/11/24. An admission notice dated 26/11/24 without challenging the terms and conditions of the said notices, and as such, at this stage, the petitioner is debarred from making the plea that the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree Rules 2021, amended up to date, is not applicable for the candidates who has participated in the counseling process for admission into postgraduate courses in the Medical Colleges of Assam for the session 24-25. So basically, my lord, if your lordship sees, the ground is, my lord, that first ground is the last date of submission of application was 16/4/24. So the contention is the rule had already come into force before the last date of submission of application. And secondly, my lord, the second contention is the petitioner participated in the admission and counseling process in terms of the education notice 14/11/24 and admission notice 26/11/24, not having challenged the same. So therefore, essentially the stand is the 2024 amended rule applies in my case. And since admittedly, I don't have the continuous, my lord, service of 5 years. So therefore, my rejection, my lord, does not suffer from any infirmity. That is, my lord, their stand. Now, in this regard, my lord, my first respectful submission is that the amendment, my lord, having been made subsequent to issuance of the, my lord, selection process, my lord, that cannot be applied in a retrospective manner. Now, the respondent, my lord, DME, my lord, is silent in respect of our contention that the selection process has initiated from the date of the first notice. And I'll come to that. There is no denial, my lord, to this particular paragraph. So by, my lord, applying the doctrine of no traversal, my lord, that particular contention is accepted by the, my lord, Director of Medical Education. Now, having said that, my lord, what is the law with regard to, my lord, the application of an amended rule in respect of an ongoing selection, my lord? Now, in this context, my lord, I may place, my lord, one judgment of the recent judgment of the Supreme Court, my lord. This is a, my lord, Constitution bench judgment. It was a populated law. My lord, this is a 7 judges bench, recent, my lord, judgment. It is reported in 24 Supreme SC 1001. Now, essentially, my lord, this is a reference before the Constitution bench. Now, the reference has arisen out of this, my lord, particular, my lord, conflict between two judges bench, two, my lord, conflicting, my lord, judgments. One, my lord, in K. Manjusri's case, and the another, my lord, in Subhash Chandra Marwaha case. Now, K. Manjusri, my lord, in no uncertain terms, my lord, has held that once, my lord, selection process starts, it is initiated, my lord, the amendment cannot be applied, either in a retroactive manner or retrospective manner. Now, there is a conflicting judgment in respect of Subhash Chandra Marwaha, my lord, which says, my lord, that it can be applied. Now, while proceeding to render the judgment, what the Honorable Supreme Court found, that my lord, if I take your lordships, my lord, to this part, then it will be more, my lord, candid. If your lordship comes to page 8 of 26, my lord, your lordship will find the page numbers down below, page 8. Now the reference, my lord, is in a clear terms, referred in para 15 of the top, my lord. Then I'll come to the relevant paras. Your lordship has got it, para 15, my lord. This is part of the reference, my lord, para 15. Page 8, my lord, second para. No doubt, it is a salutary principles not to permit the state or its instrumentalities to tinker with the rule of the game. Insofar as the prescription of eligibility criteria is concerned, as was done in so-and-so case, in order to avoid manipulation of the recruitment process and its results. Whether such a principle should be applied in the context of the rules of game, stipulating the procedure for selection, more particularly when the change sought to be imposed a more rigorous scrutiny for selection requires an authoritative pronouncement of a larger bench of this court. We therefore order that the matter be placed before the Honorable Chief Justice of India for appropriate orders in this regard. Now, what the Honorable Supreme Court found, my lord, that this expression, my lord, rule of the game, it has two perspectives, my lord. The first perspective is in respect of, my lord, the basic qualification, the eligibility criteria. And the second perspective, my lord, is in respect of, my lord, the manner and method of the selection. My lord, not affecting the right of the candidates. And this is more lucidly, my lord, referred to para in, my lord, described, explained in para 5, down below, my lord. In various judicial pronouncements, the law governing recruitment to public services has been colloquially termed as the rule of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once the recruitment process commences. This has crystallized into an oft-quoted legal phrase that the rules of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. Well, here it is described. One which prescribes the eligibility criteria, essential qualification of the candidate seeking employment, and the other which stipulates the method and manner of making selection from amongst the eligible candidates. So therefore, my lord, eventually what the Honorable Supreme Court held, that the amendment is permissible in respect of, my lord, the manner and method of this, my lord, selection. But so far as, my lord, the basic qualification is concerned, my lord, amendment is not permissible in respect of an ongoing selection, my lord. And para 7 makes it clear. The law is settled that after commencement of the recruitment process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per advertised criteria. Such alteration change therefore deprives a person of the guarantee of equal opportunity in matters of public employment provided by Article 16 of the Constitution. This reference order therefore acknowledges this legal position and in clear terms accepts that the rule of the game cannot be changed after commencement of the recruitment process insofar as the eligibility criteria is concerned. So the reference, my lord, in respect of this proposition that the eligibility criteria cannot be changed. Now, eventually, my lord, what the conclusions are drawn, I'll take your lordships to that. But before that, I take your lordships also to page 11, my lord. This is a relevant para for me, and I'm focusing on it. Page 11, para 13. Now, before proceeding further, my lord, my respectful submission is, it is in respect of a recruitment process. But the analogy, my lord, the principles will apply in respect of a selection and admission also, my lord. Because the selection has to essentially conform to the rules, my lord, of Article 14, the norms of Article 14. So the analogy will equally apply in my case also, my lord. Now, 13, my lord, reads as follows. The process of recruitment begins the issuance of advertisement and ends with the filling up of notified vacancies. So the moment it is advertised, my lord, the process starts. And until the vacancy, my lord, is filled up, the process continues, my lord. It consists of various steps like inviting applications, scrutiny of application, rejection of defective applications, or elimination of ineligible, conducting examination, calling for interview of viva voce, preparation of list of successful candidates for appointment. So, my lord, this is the, my lord, paragraph which says that once the advertisement is issued, the selection process starts. Now your lordship will come to the conclusions drawn by my lord, the reference court, the constitutional bench at page 25. 1, 2, and 3, my lord, are relevant for me.
Yes.
Number 1, 42. Recruitment process commences from the issuance of the advertisement, calling for applications, and end with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway, though the recruitment process, unless the extent rule so permit, or the advertisement which is not contrary to the extent rule so permit. Even if such change is permissible under the extent rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Now, pausing for a moment, my lord, in para 2, what is said, my lord, that midway through you cannot, my lord, amend the rule in respect of the qualification. But that would be permissible if the rule, my lord, permits. So therefore, the rule should expressly provide that it is applied in a retrospective manner. I have another judgment in this regard, my lord. And that too, my lord, the retrospective application has to be tested, my lord, in the touchstone of Article 14. If your lordship finds that the retrospective application, my lord, causes prejudice or it violates the Article 14, then your lordship will strike it down. So unless, my lord, rule says that it can apply in a retrospective manner, my lord, such an amendment cannot be, my lord, made applicable in respect of an ongoing selection, my lord. Number 3, my lord, the decision in K. Manjusri, my lord, has been held to be a good law, which says once, my lord, the selection process starts, you cannot apply in respect of, my lord, the change of qualification. It can be applied, my lord, in respect of the manner and method of the application, my lord, the selection process, which does not affect the right of the candidate. So now, having said that, my lord, my respectful submission is the selection process in the present case, my lord, was initiated by the admission notice. If I take your lordships, my lord, to the facts now, the first admission notice, my lord, is at page 29, dated 9/11/23.
Yes.
So your lordship will kindly mark the date 9/11/23. For, my lord, the amended rule 13th of March 2024. Now your lordship will also take note of the date. The NEET PG 24, the scheduled date is 3rd March 24. So had, my lord, the dates not been rescheduled, by this time, my lord, the examination would have been held in terms of this notification. And there would have been no occasion for the respondents, my lord, to apply the amended rule in my case or in the case of the other candidates, my lord. Number 1. Number 2, my lord, if your lordship comes to,
It was conducted on 11th of August
it was conducted on 11th of August, my lord.
after the amendment came.
Yes, after the amendment came. But my respectful submission is, there are notices, my lord, which are part of the record. By these notifications, my lord, the examinations are scheduled. So in terms of the constitution bench, the moment, my lord, it is advertised, one has to understand that the process has commenced. Process has commenced until, my lord, and unless the posts are filled up. And in this case, my lord, until the seats, my lord, are filled up, admissions are given. So my respectful submission is, this is the document which has initiated, my lord, the selection process. Subsequently, my lord, there is another, my lord, document, notice 9th of January 24,
With that,
page 30, my lord. By this, my lord, notice, the date has been rescheduled to be 7 July 24. Then there is another notice, my lord, 31, 11th August 24. So these particular notices, my lord, they are, in my respectful submission, are complementary to the initial notice. by which, my lord, the selection process was initiated. This subsequent notices, rescheduling, my lord, the examinations, my lord, it does not give rise to any fresh cause of action. The cause of action has arisen, my lord, in the November 2023. Now, if your lordship comes to, my lord, the information bulletin, which is relied on by the respondents, my lord. Page, my lord, starts from page 61. This information bulletin is nothing, but it indicates the date of 16 April 24 regarding the online submission of application, examination date 23rd June 24. Now, on this information bulletin, the respondent has relied on, saying that on the basis of this, my lord, I have submitted the application. But having regard to the date, my lord, the notices, even this date of 23rd June does not survive at all. Examination was not held on 23rd June 24. It was held on 11th of August 24. So therefore, my lord, this is not a sacrosanct document which will, my lord, unsettle the settled proposition of law. My respectful submission is the selection process having been initiated by the notice, my lord, of November 23, until the seats are filled up by 31st of December 24, my lord, this is an ongoing selection process. In terms of the constitution bench, midway through, you cannot amend the qualification. You could have done it in respect of the manner and method of the selection. But in respect of the eligibility criteria, my lord, this is not permissible at all. This has been done. Now, by inserting continuous service, my lord, this is amounting to amend in respect of my basic qualification. And thereby I am deprived. So therefore, if your lordship takes up the, my lord, in this perspective, that the selection process having been initiated in the month of November 23, and it will come to an end or conclude, my lord, December 24. So during this period of 1 year period, no amendment is permissible in respect of the basic qualification. And to that context, my lord, I am relying on the constitution bench. Now, there is a division bench judgment also, my lord. I'll place that also in this regard. Motion to be due. What? Yes, huh? Mosumi. Now, similar circumstances, my lord, this division bench has held that once, my lord, the selection process was initiated, subsequently, my lord, the rule cannot be amended to the prejudice of, my lord, candidates. Now, your lordship will find, my lord, the operative part from page 6, my lord. This is 19-122. Is a division bench judgment. May I read it, my lord? The petitioners before this court all are doctors who have completed MBBS course for medical colleges in Assam. Subsequently, the petitioners appeared in the NEET PG 21 examination, which was held on 11/9/21 for admission in postgraduate degree diploma course, the result of which was declared on 28/9/21, and the petitioners are now competing for seats in the medical college in Assam for postgraduate courses. The admitted position is that in medical colleges, 50% of the seats are to be filled up under state quota, and the remaining 50% to be filled under all India quota. For the 50% seats which are to be filled under the state quota, the rules which are applicable at the relevant point of time are Assam Medical Colleges Rule 2006. Rule 60, my lord, the rule has been now quoted. We may not, my lord, go to the rule. Now your lordship will come to the next page. The observation is made here. In other words, for the state quota, only such candidates were to be considered who have done MBBS course from a medical college in Assam, which is by the Medical Council of India. Subsequently, the government of Assam brought a new rule, superseding Rule 2006, which is known as the Medical College Assam Rule 2021. Now, 5 has been, my lord, mentioned here. Your lordship may also skip this one. Now, my lord, next page, your lordship will come. Page 9. The difference between the earlier rule 2006 and 2021 rule is there. Whereas under the rule 2006 rules, only the doctors who had done MBBS course in a medical college in Assam, recognized by the Medical Council of India, were eligible to get a seat in postgraduate course in medical college in Assam under the state quota. But under the new 2021 rule, the doctors who have done MBBS course from a medical college in Assam, as well as those who have done medical MBBS from any medical college outside Assam, as were eligible for consideration under the state quota. Then your lordship will come to the, my lord, next page. In between, my lord, this is not relevant for us. So I am taking your lordship's, my lord, to the page 10. Here, my lord, the division bench has held. Under these circumstances, although there are larger questions which have to be examined by this court regarding institutional preference, etc., purely on the ground that the new rules have been brought in December 22, whereas the process for admission into postgraduate MBBS course itself started in January 21. And the NEET examination was held on 21, the result of which was declared on so-and-so is an important consideration. The admitted position is that Rule 2021 had come into force with effect from 2021, whereas the result of the NEET examination had been declared much before the Rule 2021 were notified. So essentially the division bench has held that once, my lord, the process started, subsequently you cannot change the rule and apply it. So this is a proposition in respect of, my lord, my submission, the authority which supports, my lord, my case. And another, my lord, judgment has been referred. At this juncture, learned Advocate General, in his usual fairness, submits that there is indeed a decision of this court in so-and-so, wherein a similar situation had occurred. In the said case, petitioners who were seeking admission in MBBS MD course in the medical college in Assam had been rendered ineligible as per Assam Rules 2017, which stipulated that in order to be eligible for admission into the MBBS course, the candidate must have studied in all classes from 7 to 12 in the state of Assam. Earlier, the admission into the MBBS MD course in the medical colleges of Assam was governed by the Medical College of Assam and Dental Rules 2015. The 2015 rules were repealed by 2017 rule. The aforesaid 2017 rules were challenged on the ground that the said rule had been notified after the result of the examination had been declared, and this argument was accepted by the court. The writ petition was allowed, and this court directed respondents to ensure admission of the petitioners under 2015 rules. This is exactly a similar situation as one of the present case. The only difference is that aforesaid writ petition was in respect of MBBS course, whereas the present case in respect of postgraduate course. In view of the above, we have the considered opinion that interference is called for in this case. We have been informed that the first round of counseling is going to start from tomorrow, which will continue till 24/1/22. Under these circumstances, we direct that the counseling for admission into postgraduate courses under the state quota of Assam shall go on as per the criteria for admission laid down in 2006 rule and not as per 2021 rules. This is
What is the final outcome of?
my lord, they got the admission, my lord. They were considered.
No. The final outcome of this petition.
The petition was
Allowed, no?
no disposed of.
It was disposed of, my lord. I am told, as per inspection. It was disposed of.
Where is the order?
Order was in. I'll furnish that order, my lord, if necessary. I'll place that. Order to Liabadia. So, my lord, my respectful submission is, in my case, my lord, this has been initiated in the, my lord, in the year 23, and subsequently, my lord, the rule has been amended in respect of, my lord, the, my lord, basic qualification, which cannot be applied, my lord, in the present case. Now, my lord, I take your lordship to, my lord, para 20 of my writ petition. At page, my lord, 16. My lord, this is the ground which we have taken. That it is stated that, lordship, my lord, page, my lord, 16, para 20. That it is stated that the Medical College of Assam amended rules 24 is not applicable in the present case in connection with the petitioner admission, as the process of admission was started much before the rules of 2021-24, while 21 rule was in force and initial notice was issued on 9/11/23 by the National Board of Examination in Medical Science, New Delhi, fixing the date of NEET PG and the amendment rules 24 came into force much after started the process of admission in NET PG 24. Therefore, the case of the petitioner may be considered under Rule 7, Sub-Rule 1C of the my lord, Medical Colleges Assam Rules 2021. Now, your lordship will see essentially the argument is the initial date is 9/11/23. Now, what is the response, my lord? Your lordship will see the affidavit in opposition. There is even no denial to para 20 that the starting date is not 9/11/23. If your lordship comes to para 9, they have taken care of para 20 in para 9. In view of the statements made herein above, all other statements made in 1920 of the writ petition are being denied herewith. But they have not responded. They did not say that the selection process did not start in November 23. It started pursuant to the amendment of the rule. This is not their case. Our case is specific. And in terms of the constitution bench, once the advertisement is issued, process starts. Once it is notified, the subsequent notices, my lord, are only complementary to the initial notice, my lord. They are complementary. That they are not giving any fresh cause of action, my lord. So essentially, one has to understand that the selection process started, my lord, from the first notice, 11, my lord, November 23. And this aspect of the matter is not taken care of by the respondent. So my humble submission, my lord, in my case, since this is an amendment in respect of the basic qualification, therefore, in terms of the constitution bench judgment, you cannot apply in respect of my case. My lord, my lord, I have an alternative argument in respect of, my lord, without prejudice to my first contention. Now, my lord, normally what happens in such type of, my lord, selection and admission, the entire selection comes to an end by 31st of May of, my lord, that particular year. And therefore, my lord, the academic session starts from June. So therefore, your lordship will find a reference, my lord, in the rules that the cutoff date is 31st May. But in the present case, my lord, the entire things, my lord, have, my lord, moved in a different way. And the admission will conclude, my lord, only in the month of December. And the notices, my lord, disregard, I place your lordship, which is not part of the records, my lord. Ekon Jackson. My lord, this admission notice, education notice indicates, my lord, that the second round of counseling has started from yesterday, 12/12/24. If your lordship comes to the table, my lord, this makes it clear. 12/12/24 to 14/12/24. These are online registration and various steps, my lord. And eventually, my lord, the reporting date, who gets the, my lord, the admission, they have to report to their respective, my lord, medical colleges by 27 and 28. So essentially, my lord, the selection process which was started in November 23 will conclude, my lord, by December 24. Now, in this regard, my lord, my respectful submission is, my lord, having regard to the provisions of Rule 23, 24 and Rule 25, which I draw your lordship's attention, these rules, by invoking these rules, my lord, what the respondents can do, the cutoff date, my lord, for considering the eligibility criteria, my lord, has to be understood to be 31st of December. Because by 31st March, my lord, this did not conclude. And under the rules, my lord, the selection committee, government, and the rulemaking authority has the power to interpret the rules with regard to the changing circumstances. Now, if your lordship accepts this proposition, my lord, then even, my lord, without prejudice to my first contention, if your lordship accept this, my lord, that the cutoff date has to be considered to be the last date, or when the, my lord, admission concludes to be the 31st December, 2024. Then by the time, by October, my lord, my lord, in my credit have the, my lord, continuous period of 5 years. Because I joined, my lord, I joined, my lord, in, my lord, 31st 10 19. Then by 31st 11 24, there is a continuous service in November itself. And if your lordship takes up, my lord, these provisions in the rule, without prejudice, my lord, to my first contention,
Which rule?
if your lordship comes to page 48, these particular, my lord, provisions are not amended. These are still, my lord, in force.
Yes.
If your lordship comes to 23, in case of any doubt regarding interpretation of any clause of these rules, the decision of the selection board regarding the interpretation of that particular clause shall be final. So the selection, my lord, body, which is headed by the DME, is also competent to interpret the rule. Secondly, power to relax, my lord, the state government has the power where the government is of the opinion that it is necessary to expedient to do so, it may by order, not inconsistent with the provisions of these rules, and for reasons to be recorded in writing, relax any of the provisions of these rules. Then, my lord, 25, removal of difficulty. If any difficulty arises due to any of the provisions of these rules, the department may by order make such provisions not inconsistent with the provisions of these rules as may be necessary or expedient for the purpose of removing of the said difficulty. So 23, 24, 25, my lord, the competent authority, my lord, has the power. It is not denuded of the power, my lord. In appropriate circumstances, my lord, to interpret the rule and, my lord, to do the substantial justice to the candidates. Now, your lordship will see my certificate, my lord, which shows that if your lordship considers it as on 31st December, apart from having, my lord, 5 years continuous service, I have, my lord, more than 6 years service, my lord. If your lordship comes to page 23, my lord, this is the first certificate in respect of my experience, my lord. Compulsory 1 year. 1 year, my lord. Page 23. And this is, my lord, issued by the competent authority. This is not denied. This is to certify that so-and-so has completed 1 year compulsory rural posting at Meselkwa MP HC, Agia, from 9 April 18 to 8 April 19, continuously and satisfactory, 1 year. Then your lordship will come to second, my lord's certificate, which is at page, my lord, 28. This is also by the joint director, the competent authority, my lord. This is to certify that Dr. Jennifer Kaifi Ahmed has been working in regular service in Gorjan SD under Singimari BPHC Nagaon, situated at Gorjan village of Singimari subdivision in the Nagaon district, Assam, with effect from 31/10/19 till date. I am serving till date, my lord, for a period of 5 years, 4 months, continuously and satisfactory, which is a rural area as defined under Rule 2, 22 of Assam Medical College, Rules 21. So here 5 years, and, my lord, the other one 1 year. So it is not, my lord, 6 years. It is not the case, my lord, that I am underqualified. I don't have the qualification. I am asking for something which I do not deserve, my lord, or I am not entitled to. I have the qualification. You are seeking to, my lord, apply a rule which does not apply in the selection process in terms of the constitutional bench judgment, and thereby you are depriving me. This action, my lord, is absolutely arbitrary. I have the qualification, my lord. 6 years to my credit. And if your lordship accept this proposition, that if the cutoff date is, my lord, accepted to be 31st of December, I have continuous service otherwise also. So my respectful submission, my lord, the denial of the seat, my lord, has resulted, my lord, in injustice, which is absolutely arbitrary, my lord, and illegal. So your lordship will issue mandamus for giving me the seat, my lord, in respect of the select list, which I have already acquired. So what my learned friend says, I'll reply to that, man.
May I please, your lordship? My lord, the candidature of petitioner has been rejected on the ground that she doesn't have completed 5 years of continuous service, my lord. Because in the first phase,
The rejection order issued?
no, my lord, that has not been, but there is a,
My lord, they say it is, my lord, recorded in the form. If your lordship sees, my lord, the counter affidavit, and form was not communicated. My lord, I draw your lordship's attention to this part. It is important, my lord.
Which form?
Yes, my lord. They say, if your lordship comes to, my lord, para 6, my lord.
Para 6, my lord, I have stated, my lord. The reason for the rejection of the candidature of the petitioner was written by the in the body of a declaration formed by the board. But fact remains that, my lord, she has been uh, she was informed about her non-eligibility of state health service quota for admission in PG courses in the Medical College of Assam session 2024. And the reason for the rejection of the candidature of the petitioner was written in the body of the declaration formed by the board. And the reason was written in her presence, my lord. And apparently there is no dispute that for what reason she has been rejected, my lord. Because for not having...
What is this declaration for?
My lord, while submitting form, online application form for counseling, my lord, while she appeared in the counseling process, there, my lord, the form was there, my lord. So there it has been written, my lord. If your lordship wants, that can be produced from the authority, no problem, my lord. The fact remains that she has been rejected due to the reason that she has not completed 5 years of continuous service. Otherwise, my lord,
That's the basic ground.
that is the basic ground. That is the main ground.
One ground.
Yes, my lord. Now your lordship has to see when the, my lord, process has commenced, my lord, because the my learned friend who has relied upon the a notice dated, my lord, 9/11/2023 at page 29, my lord. It is a notice, my lord, by which tentative schedule for various examination under National Board of Examination in Medical Sciences were notified. Tentative dates, my lord, that cannot be said to be the date from which the NET 2024 has commenced, my lord. Page 29, my lord. It is a tentative schedule for various examination under this board, my lord. So here, my lord, NET PG 2024, my lord, it is tentative. And here also date of examination tentative, 3rd March 2024, my lord. So it was a tentative date. So this date cannot be considered as the commencement date of this examination process, my lord. So our contention is that, my lord, the examination process started with the issuance of the information bulletin, my lord, which your lordship will find at page 61, my lord. So it can be said in terms of the Constitution bench, my lord, the advertisement that have been referred in the Constitution bench judgment, this information bulletin may be treated as the advertisement, my lord. And it was published in the official website in the month of April 2024.
Where?
Page 61, my lord. Annexure A.
When was it published?
My lord, that date I cannot have because it was downloaded in the official website. But my lord, relevant date is, my lord, online submission of application. Page 62. Relevant date is, my lord, online submission of application. It was, my lord, 16 April 2024, my lord. So our contention is that, my lord, the process, the eligibility criteria, my lord,
When was this information bulletin published?
in the month of April 2024.
Month of April.
Yes, my lord. Because the date has been notified with effect from 16 April 2024, my lord. It was uploaded in the official website, my lord. And exactly when it was uploaded, probably my learned friend can say, who is appearing for the National Board of Examinations, my lord. So our main contention is that, my lord, the eligibility criteria has to be determined on the date when there was the last date of application, my lord. Last date of submission of the application. Because, my lord, my learned friend has referred to a division bench judgment, my lord. In that judgment, my lord, the amendment was brought after the declaration of result, my lord. After the examination and after the declaration of result, that in that division bench judgment, my lord. And in that judgment,
According to you, the eligibility is to be determined from the last date of
submission of application.
last
And
date
your
of
lordship will
submission.
find, because in the division bench judgment, one judgment has been referred by us, my lord, the learned advocate general has referred one judgment. Your lordship will find at page 11 of the division bench judgment, my lord.
Yeah.
One judgment has been referred, my lord, in WPC 448 2017, my lord.
Page 11.
Yes, my lord. Page 11, one judgment of the WBC number 4482, first paragraph, my lord, 4482 2017. That judgment I have produced. And that judgment, if your lordship produces that judgment, my lord, paragraph 30, if your lordship comes to paragraph 30, my lord, because the division bench judgment says that, my lord, in that case, my lord, the amendment came after the publication of the result, my lord. And in Puri Chaudhuri, my lord, the point has been clearly stated at para 30, my lord. Para 30, if your lord, the Supreme Court in Dolly Sanda versus Chairman TE reported in so have declared that while applying for any course of study, the person must possess the eligibility qualification on the last for application. The period of for application for this year's admission was scheduled during so-and-so to so-and-so, and hence the eligibility for the petitioner must be with reference to the last date of application, that is so-and-so. So, accordingly, it was held that therefore the admission must be granted on the basis of the norms prevalent on the date when the aspirant could last apply, and logically, therefore, the new rules cannot apply. So, my lord, it says, so the norms and terms and norms prevalent at the date when the last date of application was there, my lord. So our contention is that on that day, my lord, new amended rule has come, my lord, because the new amended rule has published in the official gazette on 13/3/2024. So on the last date of the application, my lord, new amended rule is there. And in this context, my lord, another judgment I would like to refer, my lord.
Copy दिया ना
My lord, para 7, my lord. Para 7 of the judgment, my lord. And last line, my lord. Therefore, the relevant date for considering the essential eligibility criteria as per Appendix A shall be the date on which the candidate petitioner sought admission in the MBBS course under PWD quota. So, my lord, is clearly laid down the guideline that what will be the date on and which rule will be the rules that is prevailing on the date when the application was made. So it means that when the last date of submission of application was there, it was 16/4/2024. And amended rule came into operation with effect from 13/3/2024. So therefore, the amended rule will be applicable. And secondly, my lord, the education notice and admission notice issued by the authority, my lord, at page 63. Page 63, it is the first educational notice issued by the DME, my lord, authority. So in that educational notice, in second paragraph, your lordship will find, my lord.
Yes.
Page 63, my lord. Page 63, my lord. Educational notice issued by the Director of Medical Education, my lord. in the second paragraph, the first round online counseling for admission into fees 50% postgraduate seats in the government medical colleges of Assam and BBCI Guwahati under Assam State Quota for session 2024 will be held as per the Medical Colleges of Assam Regulation of Admission into Postgraduate Degree and Diploma Courses Rules 2021 amendment up to date. So here also, my lord, it has been notified. The petitioner never challenges this or never raises any objection regarding this. Subsequently, my lord, the admission notice was issued on, my lord, 26/11/2024, my lord, where is also, my lord, the same condition has been stipulated. Page 65, my lord, your lordship will find. Page 65, my lord, the terms and condition clause number 1, my lord. All admission shall be provisional and will be subject to fulfillment of all the requisite eligibility criteria as per the so and so amendment rule, my lord. So my first submission is on the last date of submission of application. So my first submission is that, my lord, on the date of last date of submission of application, my lord, new amended rule came in, my lord. So accordingly, my lord, in terms of the guidelines laid down by this honorable court as well as the Supreme Court, my lord, the date of determination of the rule which will be applicable, that will be the, my lord, the rule which was prevailed on the last date of submission of application should be applicable. And secondly, the petitioner participated in the process, my lord, in terms of the educational admission notice, my lord, without raising any objection or making any challenge, my lord. And secondly, my lord, one regarding the submission made by the petitioner side, that, my lord, because as per the rules, my lord, the eligibility criteria was that continuous service on 31st of May. So that is in terms of the rule. Now it doesn't matter, my lord, when the examination was held. Every year the dates may be different, but the norms is that eligibility criteria has to be fulfilled on 31st of May 2024. So accordingly, my lord, because second round of counseling has started.
We'll do one thing. We'll take over Monday. Let me go to this report that one.
Yes, my lord.
But it's Monday. Apollo. You want Monday or Tuesday?
Tuesday.
My lord, Tuesday will be late, my lord, because the process is going on, my lord.
One seat already vacant, my lord.
No,
Vacant.
keeping the seat vacant, only, my lord, that creates more complications.
Monday
my
have
lord,
some difficulty, man.
on Monday, my lord.
Have difficulty, man. Tuesday, man.
Monday, many cases.
Yes. Tuesday.
Yes, my lord.
In the motion column, man. Yes, oblige.
Yes, as first item,
If you oblige.
Obligement.
Her service, my lord, she had applied for leave for her treatment of cancer, my lord. But though her retirement benefit was granted, but her leave encashment salary was not clearly granted, my lord. I have filed application also, my lord. And the headmaster has forwarded my application. Last annexure, page 42.
yes, Bora, you can take some instructions.
My notice may go at it.
Okay, heard, Mr.
The word.
And counsel for the petitioner issue notice. Mr. P.K. Bora, that's standing counsel, elementary education, appears for respondents.
1, 2, and 3, madam.
Three. Mr. D. Bhattacharya, standing counsel, appears for response 4. Pension. Finance, Mr. R. Babujani, standing counsel, finance, appears for 5 and 7. And Mr. P. Cycle and government advocate appears for the respondent number 6. Notice on respondents. Extra copies. List. One allowed to file affidavit. List after 4 weeks.
Published. Item 10.
May I please, Lordship?
Mhm.
Lordship, matter regarding denial of pass certificate. Lordship. Denial of pass certificate. Lordship.
Okay.
Lordship, petitioner participated in the state eligibility test 2024. Subsequently, he was declared pass in the result, but he was denied the certificate. Lordship, state eligibility test is a qualifying case.
Mm.
Is after getting the certificate, he can eligible for the apply for the test and
It's just like NET, Milord, it is organized by the examination is held by the state,
Who denied your this thing?
the state
Lordship,
commission, state commission.
Slate commission, Lordship.
State.
Slate commission, Lordship.
Okay.
Consideration number 2, Lordship.
Page.
Lordship, the denial is not there, but I have filed an RTI application.
Hmm.
In the reply to that RTI application, they have informed that
Reply to
this certificate has been denied, Lordship. Lordship,
Where is
will
that? Where is
find my RTI application at page number 65, Lordship.
Yes.
Lordship, may I read, Lordship? Lordship, I have sought.
Okay. And then where's the reply?
Lordship, the reply is that Lordship, page
68.
68, Lordship. Lordship will two inform Lordship will type specifically Lordship 6, Lordship, and page 69, Lordship.
Hmm.
And point number 6, there is stated. Very, Lordship. As regard the information as sought for by your application number under serial number so and so, it is to inform that as per clause number so and so of the information procured, and embargo was given to the candidates who does not have the required qualification and or valid certificate did not apply, and that the original mark sheet and the certificate of the candidates will be verified at the time of issuance of the qualifying certificate.
Okay.
It has also been notified that information required that candidate in their own interest must satisfy themselves about eligibility. So and so. And the next parallel. Therefore, during verification of the mark sheet and certificate of the candidate, if the commission finds that the candidate who claims himself partially under
It seems,
OBC
Milord, that his results was denied because of the fact that at the time of filing the application form, filling up the application form, though he had the OBC certificate, but he did not submit the non-creamy layer certificate.
And-
What he obtained, of course, later on. He obtained it, but it was later on. That is the reason, perhaps.
Okay. But the others will have to, they'll have to.
Well, the slate don't have a standing counsel.
Oh, they don't have.
They don't
Then
have.
notice has to go.
Yeah, notices.
Heard, Mister?
Hey, Google.
A go go.
Okay.
Then the council issue notice. Mr. A. Chamal and the standing council UGC appears for the respond number 1, correct?
Well,
Stop. And Mr. B. Cycle and government advocate appears for the respond number 3. Extra copies. Petitioner to take steps for service of notice on the respond number 2 by registered post AD within 1 week. Respondents are allowed to file affidavit list after 4 weeks.
well,
Definitely.
may I get an extra copy? Please?
I've ordered.
11.
Well, this case is covered by the judgment passed by this Honorable Court Division Bench, my lord. Our service has been provincialized as tutor, and that clause has been challenged by some of the petitioners before the division bench. And two division bench has held that we are also entitled to similar treatment as teacher, my lord. And one method, your lordship directed the authorities to produce instruction. That method is fixed on Monday. So this matter may be fixed on Monday, my lord. Limited pair, whether this case is also covered by the judgment.
In other case, my lord, notice has been issued, my lord. Let notice be go, my lord.
Let it come Monday, my
Is
lord.
it coming up on Monday?
Yes, my lord.
Are you sure?
Yes, yes, my lord. Sure.
My lord, regarding notice matter, my lord, maybe coming up on Monday, my lord, but other matters, my lord, notice has already been issued.
Let it come up on Monday. We'll
Yes.
see what we can do.
Yes.
On request made by Sharma, let me come to the petition. List down. 16th.
My lord.
12.
My previous lordship, my lord. In this case, my lord, the petitioner was a student of a particular school, my lord. My lord, she is a student of, my lord, a government girls' higher secondary school, Lekawali, Arunachal Pradesh. And she, my lord, appeared in the standard final examinations, and subsequently they issued notice there is some anomalies, my lord, regarding date of birth. And she applied for, initially she came, approved this novel court for correction of surname and name and surname. Then they, as per the direction of the court, they issued, my lord, certificates afresh. Then there appears one more, my lord, mistake, an error regarding date of birth. Then she, my lord, again approved the CBSC, and after observing all, my lord, formalities and procedure, she submitted application, deposited, my lord, requisite fees. Matter was, my lord, referred to, my lord, particular principal of the school, seeking recommendation by the CBSC. Recommendation was submitted. Now they are taking the stand that since there is a bar under bylaw 69 of the revised bylaws of, my lord, CBSC, therefore we are hardly in a position to consider your case. In the meantime, my lord, the issue was, my lord, raised before Supreme Court in Jaggi, my lord, Jadav's case. That was decided in 2021. Supreme Court says, my lord, restriction that was imposed regarding, my lord, entertainment of the application is absolutely in violation of Article 14 of the Constitution of India. There cannot be any restriction or limitation. Otherwise, it will amount to Article 14, 19, and 21. So I will examine this question whether I'm entitled in terms of that decision. I have enclosed the decision of the Supreme Court, height annexure N. And at this stage, notice may be issued.
Okay, Mr. Kapuka is still in a senior counsel. Assisted by? You are assisted by?
Yes, sir, my lord.
Then the counsel for the petition. Issue notice. Who appears?
Your lordship, I appear on behalf of Mrs. R. Bora. She is totally today unwell.
Union of India.
From 1 to 6, your lord.
Mr.
D. Bora.
D. Bora, legal counsel, appears on behalf of MS.
R. Bora.
R. Bora,
Standing Council CPS.
Standing Council, CBSC. For the union, you can appear.
Yes, yes. 1 to 6.
You can appear for.
Yes, yes. There is a notification to this effect.
Okay, for the respondents, 1 to
6.
1 to 6. Extra copies.
My lord.
Petitioners to take steps for service of notice on respond number 7 by registered post AD within 1 week.
Obliged, Your Honor.
Respondents are allowed to file an affidavit within 4 weeks.
13.
Is a senior confident.
May please the lordship. In this case, my lord, issue is regarding the new pension and old pension, my lord. We are initially appointed in the 90s, my lord. Thereafter, Monoharan Committee has been set up. In 2001, we are, my lord, cleared. And thereafter, 2005, our services were regularized with new pension scheme, my lord. Thereafter, several writ petitions follows and writ appeal follows. And during the pendency of the writ appeals, my lord, the government take a decisions to give benefit of old pensions to those employees who joined the services after January 2005, but their process were started prior to that, my lord. And on the basis of that decisions, my lord, a batch of writ appeal has been disposed of. We are seeking similar kind of relief because, your lordship, on those batch of writ appeal, some teachers are party as a petitioners, my lord, in a writ appeal, and those their services were regularized along with us, my lord. And thereafter, the government has proceeded their cases, but our cases was not proceed with, my lord. In this regard, my lord, I beg to refer your lordship page number 131. This is the minutes of the meeting.
That is reflected in the bid appeal.
My lord, reflected. On the same line, my lord, this matter will be disposed of, my lord.
At this stage, my lord, notice or my lord, I may grant some time to take instruction, my lord, whether they are similar or not, my lord.
In this regard, my lord, I beg to refer the regularization list. On the same list, we are there, my lord.
That actually. But Mr. M.A. Hussain, learned counsel for the petition. MSS Tutel and Standing Council, Elementary Education.
My lord.
How much time?
Immediately after vacation.
Please for 2 weeks time to enable her to receive instructions.
But I'm paying for extra copies, my lord.
List after 4 weeks. List after 2 weeks. You furnish a copy.
That may be given, ma'am.
It will come up after vacation. I'm not fixing dates.
Item 60.
May I please allow? In this case, also, lordship, the petitioner is paying for considering his case for the old pension scheme, but that has not been considered. And the service was regularized in the year 2002, and he was initially appointed in the year 1995. Now, certain relevant aspects of the matter that has not been taken into account by the respondents. So basically, we are challenging the points raised by the respondent in not considering the case of the petitioner under the old pension scheme. Your lordship kindly see the order dated this 31/3/1995, the annexure 1, in which the petitioner was appointed, and there was a requirement of undergoing teachers training program for a period of 1 year. So that he took in the year 2004 prior to 2005. And the respondent authorities did not communicate him with regard to the result of this teacher training course, which he undergo in the year 2003. Subsequently filed one the RTI application, lordship, and pursuant to that RTI application, he has been furnished with this result of that particular examination. And in that particular examination, it is seen that the petitioner has qualified that particular exam in the year 2004 itself. But that relevant aspect of the matter has not been taken into account. So at this stage, lordship, this notice may go so that the authorities can obtain the necessary instruction.
SP Chowdhury, learned counsel for the petitioner. Issue notice. MSS Tutel and Standing Council.
But I'm paying for 1 free, 4, 5.
For 1,
3,
3,
4, 5, and 6, my lord.
4, 5, and 6. Finance.
Our board presiding there, my lord.
Mr. R. Babujari, learned Standing Council, Finance Department, appears for respondents. 2 and 7, isn't it?
My lord.
Notice and respondents are complete. Our extra copies. Respondents are filed up.
Can a date be fixed, lordship? This person is going to retire in the month of March, lordship. In the month of
After 4 weeks. Oh, no, list on.
Oblige, lordship.
Okay.
First week of January, lordship, it is possible.
That will not be 4 weeks.
After view, then what?
Yeah, 24th
24th.
January.
Oblige, lordship.
61.
May I please, your lords.
Oh.
Lordship, petitioner is an associate professor at HOD of TU College in the English department. And lordship, there was an advertisement for the post of principal. Lordship will find that advertisement at page 43. The type copy is there at 43, lordship. So it was advertised by Bhawanipur Anchalik College.
Okay.
Page 43, lordship. So petitioner being qualified, she applied for the post. But there was a screening committee there. She applied for the post. Now, like there was no reply coming from, whether she is being selected or not. So the petitioner has written to the governing body of the college. And the governing body of the college, lordship, replied to her. That reply is, lordship will find at page 68 here also. 67 is, lordship, my letter to them. 68, lordship will find the reply. So in the reply by 68, lordship will find they have given a list of persons who have been selected by the screening committee for the
interview, but I have not been included there. Then Lordship will find at page 70 onwards, they have given the reason why I was not selected for the interview. That is, Lordship will find relevant part is page 72 here.
Where's the list?
List is at page 69, Your Lordship.
Oh,
There are 5 persons who have been selected.
your name is not here.
My name is not there.
Mhm.
Then they have given this, the whole list has been given. The list they have prepared evaluating this qualifications.
Okay.
And page 72, Lordship, the last column, that is the relevant part. Your Lordship will find that less than 55% marks in masters.
This is regarding you?
It's regarding me, Lordship. Her name is Lordship Dr. Jyoti Talukdar.
Okay, it starts from page 70.
Page 70, then like Lordship will find at page 72, last column, remark column here.
Yes.
Less than 55% marks. Now, Lordship, what has happened is that the government has issued one notification way back in 1989. That Lordship will find at page 47. So the Lordship, government has formulated one mechanism how to calculate 55, how to calculate this 55% as a mark.
Page 40?
Page 47, Lordship, it starts. Lordship will find it 9th of November, 89. It has been addressed to Principal Secretary of all deficit colleges. Page 47, has the Lordship got it? So it was addressed to Principal Secretary of all deficit colleges. So inviting reference on the subject cited above, I have honored to furnish below a copy of the government letter dated 6/9/89 for your information on necessary action. So the next page, Lordship will find the letter. Revised UGC norms for college lecturers. I am directed to say that 54.5% marks obtained by a candidate in MA, MSc, MCom final examination should be rounded off as 55%. And as such, candidate will be eligible for consideration for the post of college lecturer. So this entry percentage, so this has been, Lordship stated that if somebody gets 54.5% mark, it should be rounded as 55% mark. Now, Lordship will find, I got Lordship 54.75%. Now, Lordship will find it page 78. In 2013, the issue came to the fore again, and in this speaking order, Lordship will, I'll just read out that last bottom paragraph here, Lordship. It is therefore decided to consider the appointments of such candidates who secured 54.5% marks in their respective MA, MSc, MCom final examination made during period from 6/9/1989 to 20/2/2003, rounding off 54.5% as 55% mark as valid. And such candidates should be considered for eligible for appointment of faculty members. However, with effect from 20/2/2003, no rounding of 54.5% and above to 55% will be applicable. So there was a period they have prescribed, Lordship. If somebody qualifies for MA, MSc, MCom during the period of 6/9/1989 to 20/2/2003, then the marks should be rounded off. But however, somebody who passed after 2003, that consideration will not be there. And in this case, Lordship, petitioner has passed in 1994, Your Lordship. So petitioner falls within that period of that exemption has been given. Now, Lordship, in fact, Lordship, there are 2 other colleges, Lordship. So I have been denied for that. Look, that I have not qualified because I don't have 55. But they have already prescribed a mechanism how to calculate 55. If somebody got 55.4% marks, it should be rounded off. Now, Lordship, in fact, like there are other 2 colleges, Lordship. One college, in fact, Lordship, under the same university. They have called me for the interview. That is, Lordship will find at page 76. So my college is, Lordship, that is Bhawanipur College, which have denied me. That college is under Bhattacharya University College, and this college, Lordship, not Kamrup College. This is also under the Bhattacharya University. And they have in fact called me with the same qualification, Your Lordship. And in the Guwahati University also, under Guwahati University, next page, Lordship, will find it page 77. Another college, Tihu College. So here also, Lordship, I have been called for the interview. So in this particular college, Lordship, I have been denied wrongfully, Lordship.
When is the interview?
So Lordship, this 17th, this interview is going to be held. So Lordship may kindly allow me to at least participate in the interview, and after the Lordship matter can be heard at the earliest and can be disposed of.
Yes,
My lord, as per UGC regulations provision 10, my lord, the minimum eligibility criteria for principal is 55%, my lord.
correct.
And the state government cannot dilute that minimum qualification, my lord. So my humble submission would be that this letter and speaking order will not be applicable here in this case, my lord, because the statute and the rules doesn't provide for
Who issued
rounding
that? Who issued that order?
that is issued by that earlier one is the communication, my lord. This is only a communication to the principals by the
Lordship, yeah, Lordship, may
It's 78.
yes, my lord.
Who
Well,
issued
this is
that
a-
order?
my lord, this is a speaking order pursuant to one prayer petition by Nosad Ali Ahmed, my lord. This is Commissioner Secretary of Government of Assam. Yes, my lord. My lord, regarding this speaking order, my lord, I have to take instruction whether this is still in force or not, my lord. And another submission would be, my lord, since the statute provide that the minimum qualification is 55%, my lord, the state government cannot dilute or cannot dilute this minimum qualification, my lord. We can always
Is that a submission that you should make as a standing council of higher education department, or is it the UGC council who should make that submission?
my lord, we follow the minimum qualification.
You are the
prescribed by
standing council of the higher education department. Let the submission come from the mouth of the UGC standing council.
My lord, UGC
Not
is
you.
UGC is not a party, first of all, and the another thing is
UGC
that
is a party.
It is not a party, Lordship. Lordship, actually, what happens is that UGC regulations are just their kind of guidelines. And a state can amend it. State can have their own decisions. That has to be adopted by the
No,
state.
but at least you should have the UGC as a party.
We don't have any grievances against UGC, Lordship, because this 2013 is very clear. And like and this 19, and there is nowhere, Lordship will find it that November 89 instructions that is not has not been diluted. Nothing has been stated about that. So we do actually, Lordship, we haven't been UGC party because we don't have any grievances against the UGC.
Where's that 89 order?
89 order is pays 47 year, Lordship. That is very clear, Lordship. It has page 48, Lordship will come, page 48.
48 or 49?
Wait, 48, Lordship will come, Lordship may come. 49 is the original, 48, Lordship will come. It says revised UGC norms for college. This can be decided, Lordship. This can be decided later on. I'm not shying away for that. I'm not shying away from that. Only at this point of time, Lordship, I may be allowed. So I can take the interview after the Lordship will decide the matter. If I'm not there, I'm not there, Lordship.
When there is respect, my lord, where Supreme Court also says that rounding off is not permissible, my lord, in those competition.
Heard Mr. M. Kalita, learned counsel for the petition.
A. Kalita.
Sorry, A. Kalita, learned counsel for the petition. Stop. You are presently serving as
the head of the department English head of the department English in Tihu College, Your Lordship.
the petitioner is presently serving as associate professor and head of department in the Department of English and in the Tihu College comma, Dihu, stop. Para, stop. Pursuant to an advertisement, which was published in the Assam Tribune on 23/7/2024, for filling up
The post of the principal.
the post of principal of Bhawanipur Anchalik College, Bhawanipur, Barbita. The petitioner applied for the said post. Stop. However, as no information was given to the petitioner whether her application, his or her, whether her application has been accepted, she, where's that letter?
Yeah, page 67 here also.
She made an application before the president of the governing body of the said Bhawanipur Anchalik College with regard to her application. Stop. In response, the
President of governing body, Lord.
he is the president.
President of the governing
The
body.
president of the governing body, Bhawanipur Anchalik College, wrote on 1/12/2024 that out of 8 applicants, only 5 are shortlisted to be called for the next stage of selection process, and that the application of the petitioner has not been accepted. Stop. The reason for not accepting the application of the petitioner was due to the fact that she obtained less than 55% marks in her master's degree. Stop. Para. It is the case of the petitioner that the Joint Secretary to the Government of Assam, Education Department, by a communication dated 6 September 2009, and addressed to the Director of Public, was this instruction in public?
Instruction.
Director, now director.
Director of Public Instruction.
Public instruction. Earlier it was like that. Now it has become different.
Okay.
Lordship, higher
Comma,
education.
Assam. What did I say? This is the case of the petition that the prior communication there is directed that 54.5% marks obtained by a candidate in MA/MSc/MCom final examination should be rounded off as 55%, and such candidate will be eligible for consideration for the post of college lecturer. Stop. The petitioner also relies on a speaking order dated 31st May 2013, issued by the Commissioner and Secretary to the Government of Assam Higher Education Department, wherein it is stated that wherein a decision was taken, correct?
Decision was taken, Lordship.
To consider the appointment of such candidates who secured 54.5% marks in their respective MA/MSc/MCom final examinations made during the period from 6/9 to 1989 to 2023 by rounding off 54.5% as 55% as valid, and such candidates should be considered as eligible for appointment as faculty members. Stop. However, with effect from 2023,
203, Lord, sir.
22,
2002.
2002, 2023, no rounding off of 54.5% and above to 55% will be applicable. And only candidates who have obtained marks of 55% and above will be eligible. Stop. It is the case of the petitioner that she had obtained 54.75 marks
in her
in
master's
her master's,
in 1994, Lord, sir. Passed in 1994.
and the said degree was obtained in the year 1994. And accordingly, she is eligible for consideration in terms of the communication dated 6 September 1989 and speaking order dated 31/5/2013. Stop. I'll issue notice.
Yes, my lord.
Issue notice. Mr.
S.
S.
Das.
Das, the Standing Council Higher Education,
I'll be appearing for 1 and 2, my lord.
appears for the respondent number 1 and 2. Stop. Extra copies. Petitioner to take steps for service of notice on the respondents 3 to 6
Yes, ma'am.
by registered post AD within 1 week from today. Respondents are allowed to file affidavit. List the matter after 4 weeks. In the interim,
Lord, may I submit one thing, my lord? In this speaking order, my lord, if my lord, my lord, it is therefore decided to consider the appointments of such candidates who secured 54.5 marks in their respective MA, MSc, MCom final examination made during the period from so-and-so to so-and-so by rounding off 54.5 as 55 as valid, and such candidates should be considered as eligible for appointment as faculty members, my lord. But this assistant professor, the petitioner who is working as assistant professor, this also require 55%, my lord. Perhaps, my lord, this rounding of facility has already been availed by the.
Anyway, what
petitioner,
I'm
my lord.
saying is the petitioner is relying on these two.
Yes, my lord.
I'm not giving a final decision. In the interim,
Subject to my lord, please.
the what authority is it?
Page number 2. This is a governing body, Lord, sir.
Is the governing body or the selection committee?
Selection committee. Selection committee is
Under
under the governing body. The college has a governing body, so they have considered a selection committee. So selection committee, Lord.
The selection committee for appointment to the post of principal of the Bhawanipur Anchalik College shall permit the petitioner to appear
The interview is on 17th, Lord, sir.
in the interview held on to be held on 17th of
December
2024. Stop. Further comma. I think no final decision has to be given.
Yes, no, that can be, Lord, sir. I'm fine with that, Lord, sir. Final decision, they can keep it in abeyance till the matter is heard in matter.
No final decision with regard to the selection of the shall be allowed to interview in the health so and so. Stop. It is also provided that the final results of the selection for the post of principal of so and so college shall not be declared without the leave of this court.
Publish it.
UGC will be necessary.
Yeah,
Because at
if necessary, I think we'll have to make a party.
If necessary, we'll do it, Lordship, but we don't have any this thing about UGC, Lordship. No.
No, what,
But
what
that has to
one
be clarified
contention
by the
that is
We'll-
rising up. So you
We'll make it, Lordship.
okay.
That's all.
Oblige, Lordship.
Item 62.
My lord, there are 4 writ petition, my lord, challenging the order of transfer 62, 63, 64, 65, all are similar, my lord. Lordship, may I kindly take up 63 first, my lord. WPC 6720 2024, my lord. All are challenging the order of transfer of LP school teacher. Now here, my lord, in WPC 6720, my lord, government has a act, my lord.
1 minute. Oh. Yeah.
My lord, there is a act, my lord, that is Assam Elementary, Secondary and Secondary School Teacher Regulation of Posting and Transfer Act 2020. Now transfer can be, my lord, done, my lord, following the act, my lord. And now transfer is also done, my lord, on the basis of our own request, my lord. Own request of a teacher who has served 10 years, transfer can be done, my lord. Secondly, my lord, the authority can transfer to maintain the PTR norms as per the rule, my lord, clause 5 of the act, my lord. And thirdly, on a complaint filed by the school authority. Now, in none of these case, my lord, the petitioner case does not fall on any of these, my lord. Now, my lord, we have not filed any application seeking own request, my lord. Now, your lordship will kindly see, your lordship will see, come to the impugned transfer order, page 18. It was, order is dated 29/11/2024 and issued on, my lord, 3rd of December, my lord. Below your lordship will find.
Page
18, my lord, 1/8. Below your lordship will find that it was issued on 3rd of December 2024 and it was, my lord, given to us on 6th of December. Accordingly, my lord, we have come immediately, my lord.
But in the body of the order, it's shown 29th November.
Below your lordship, issue on date. Order was passed on 29, but it was never communicated. It was issued on 3rd December 2024, but it was given to us on 6th of December. Now your lordship will kindly come to the, my lord. In here, we are alleging, my lord, malafide as well as the violation of the PTR norms, my lord. Your lordship will kindly come to the Act, my lord, Assam Elementary Secondary School Act, page 25, my lord. Now here, your lordship, the Act says, my lord, page 28.
This is issued by whom? NC Hills.
This is your order. Your order has been passed by District Primary Education Officer, respondent number 3. This order has been passed, my lord, on 29, but actually order has to be constituted by a district level committee, my lord. District level committee has to consider the PTR norms, my lord, people teacher ratio. So that has not been followed as per the act.
Is this act applicable in this NC?
Yes, my lord. Your lordship, may I place the Justice Borua judgment 1 of the NC Hills and also Justice Pathak, my lord. Till now, my lord, the act has not been followed by this in the NC Hills, my lord.
Not followed?
Yes, my lord. Because if they follow, my lord, they have to maintain the people teacher ratio, my lord. In Justice Borua case, your lordship, entire order has been set aside for not following. Your lordship will find at 3rd subpara, my lord. That is Assam Elementary and Secondary Education Teachers Regulation of Posting Act. And similar order, your lordship will find in the case of Justice Pathak, my lord. There also, my lord, paragraph number Your lordship will find paragraph number 4. That regulation act has been violated, my lord.
Yes. Then
Then your lordship will kindly, I am alleging malafide also, my lord. Before that, your lordship will come to the malafide is that page 20, my lord. Annexure Z, my lord. Earlier, my lord, this petitioner, along with other LP school teachers, my lord, page 20, my lord. My name is at serial number 6, page 21, my lord. Mansuma, my lord. Now your lordship will kindly come to page 23, my lord. Your lordship has, this court has passed an order on 25/11. We have challenged the advertisement for the 150 numbers of post of LP school teacher, where we are also working. There your lordship will find that one order has been passed at page 23. 13 petitioners in the present written petition have challenged the advertisement so and so of assistant teacher for lower primary school under NC Hills Autonomous Council with a further prayer to regularize the case of an said 150 posts from plan to non-plan minor. He, however, submits the respondent already fill up 150 posts of assistant teacher for lower primary school under NC Hills Autonomous Council. Learned counsel for the petitioner submit that he has instruction that there are still some vacancies available due to retirement, death of incumbents. He therefore prays for an interim order for protecting the petitioners. In the meantime, last paragraph, my lord.
continue to.
Husband of this court, my lord. I was reading at page 23, my lord. Page 23 is the order of this court on pass on 20.
Okay.
Yes. Then your lordship 24, your lordship will have in the meantime, last paragraph, page 24. They were directed not to fill up the 13 posts of so and so man. Now thereafter, your lordship will see again on the transfer order was passed on at page 18. It was passed on 29 after the order has been passed. Now that I'm alleging Madam Melafeti because there was earlier also we are deprived from being sent to death. Now another point, your lordship, is that that is as per the act, page 29. Page 29, I have annexed the act of 2020, regulation and posting of teachers. Your lordship will find it page serial number section 6, subsection 6, man. Page 29. Subsection 5 and 6. So district level committee as mentioned below shall be the competent authority for recommending inter-school transfer of teacher within the district. So these are the, my lord, the committee members, they have to recommend, my lord, as a competent authority. Then your lordship will see section 6. The appointing authority shall issue the inter-school transfer order of teacher within the district on the basis of the recommendation of district level committee on being satisfied. That means a conscious decision has to be taken, my lord, that the recommendation is made in accordance with the provision of section 4 of this act. Now, section 4 again, my lord, they have to do that exercise, my lord, regarding people-teacher ratio, the number of students and number of teachers. Now, my submission is that they have not taken any such conscious decision as per the section 4, my lord.
Okay.
Subsection 4, my lord. Section 4, my lord, of the act, my lord. That they have not done. And secondly, Malafide, my lord, immediately when the court has passed the interim order not to fill up, we have been, my lord, drastically affected that you have to go to any place. The lordship will see the wordings of the transfer order itself. Nothing has been mentioned, my lord, who has passed the order, page 18, by the, whether on the recommendation of the district level committee or at the instance of some other. So, my lord.
Yes. Well, so far regarding following this particular act, my lord, I have to take instruction, but at this moment I cannot say. And regarding, my lord, the vindictive action, my lord, That order has been passed regarding regularization and not to fill up the post according with the leave of the court, my lord. That's a separate issue, my lord. That is purely assumption, my lord. My lord, kindly peruse page 19 of item number 63. After transfer order has been passed, my lord, they have written a representation, and has your lordship got it? But here, my lord, last portion, my lord. I would like to like you to grant me 8 days recover and join my duty in so and so school where I am newly posted. Therefore, I humbly request you to grant me 8 days to delay for joining my duty for this kind of act, and I will ever remain grateful to you. So they are basically not opposing that order, my lord. Anything.
No, we
They
are
are they are, my lord, agreeable to that order, and they
No.
have filed this representation. Let them, if they are agreeable, let them file
We
any
are challenging,
representation.
my lord, the legality and validity of the transfer order. They have to pass as per the act, man. If they don't follow the act, my lord, it's a null and void, my lord. Earlier, Justice Borua judgment is also there, my lord. And we have to take this time because otherwise, if we mention that you have violated the act, they will, my lord, straight away.
Okay, heard Mr. B. Barol and the counsel for the petitioner. Stop. Para. The instant writ petition has been filed challenging the order dated 29th October 2024 issued by the District Primary Education Officer, NC Hills Autonomous Council Haflong, by which the petitioner has been transferred. Serial number 2.
Yes, my lord.
From Langlut within CH LP school to what is that? Torti Langso.
Yes, my lord. Torti Langso.
Torti Langso LP school of Panimur Circle. Stop. Para. It is the case of the petitioner that the Assam elementary and secondary education teachers within bracket regulation of posting and transfer close bracket Act of 2020 within bracket the Act of 2020 in short regulates the transfer and posting of school teachers of elementary and secondary schools in Assam. Stop. It is submitted that the transfer order dated 29th November 2024 has been passed in contravention of section 5
and 6
within bracket 5 and section 5 within bracket 6 of the Act of 2020. Stop. It is the specific case of the petitioner that there is no recommendation from the district level committee in terms of section 5.5 of the Act of 2020. Stop. Para issue notice. Mr.
R.R. Kaushik, my lord.
R.R. Kaushik, Learned Standing Council.
Additional Standing Council, NC Hills Autonomous Council, Education Department.
Additional Standing Council, NC Hills
Education Department.
Autonomous Council, Education Department. Appears on behalf of the
all the respondents.
Behalf of all the respondents. Stop. Accordingly, notice on respondents are complete. However, extra copies. So respondents are allowed to file affidavit at least after 4 weeks. In the interim, the order dated 29th September 2024.
29 November.
29th November 2024. Issued by the District Primary Education Officer, NC Hills Autonomous Council Haflong, shall remain suspended insofar as it concerns the petitioner.
All are, my lord, challenging the transfer order, my lord, all the writ petition.
All same.
Same, my lord. Only, my lord, the memo number is different.
One
Order
minute.
date.
1 minute. What is 6719, item 62?
Item 62, your lordship.
Who is the order?
Page 21, my lord. Page 21, my lord. Only memo number is different, my lord. My lord.
Here you are transferred from?
Transferred from serial number 4, my lord. Maharajapur to LP school to.
Here it will be
Page 21, my lord.
Maharajpur, Desh 2, LP school to Hajawari LP school of Diungpra circle. Same order.
And my lord, item number WPC 672124. That is item number 63, 64, my lord. Page number 16. Order of transfer. Serial number 1, my lord. Lal Sunga.
Vaithang Heprun LP school to Langmiklu LP school of Garamsari circle. And the other one?
Other one, my lord, page 29, my lord. 29A, your lords will find serial number 1 and 3, my lord, both common order. Page 29A.
Serial number?
1 and 3, my lord.
Oh, these are common.
Common order, my lord.
Oh, no, two petitioners are here.
Yes, my lord.
Then the petitioners. Actually, what did I say the first line? By which the petitioner number 1.
Petitioner number 1 is Bhavani Rishi. Serial number 3, my lord.
Has been transferred from Arangaja East LP School to what is this?
That is Dong
Longkhor.
Dongkhor
Of
LP.
Hamri Circle.
Type
And
copy.
the petitioner number 2?
From Cilium, my lord.
Where? Serial number?
Serial number 1, my lord.
From Cilium LP School to
Choto
Langdam
Langdam.
LP School, Garampani Circle.
Obligation. Item 66.
May please your lordship.
Oh.
This is also in respect of an order of transfer, but the facts are a little different. My lord, the impugn order of transfer is at page 19. Before that, my lord, may I take your lordship to page 17? That is the, my lord, original appointment letter in respect of the petitioner. Annex 2 at page 70. In pursuance of the government order number such and such and subject to discharge notice, the following persons hereby appointed as orthopedically disabled candidate under served quota. So, my lord, he is a, my lord, with 50% permanent disability. And on that basis, my lord, against that quota, he was appointed. His name appears at serial number 2. Now, your lordship may kindly come to the impugn order at page 19. In pursuance of the government letter number such and such dated 27/11/2024, I'll refer to that, my lord. And as per provision provided under Section 5A of the Assam Elementary Education School Teachers Regulation and Transfer Amendment Act 2023, Nasir Chaudhary, assistant teacher of Sonapur High School, District Kamruk, is hereby transferred at his own scale and grade of pay to South Salmara, Mankasar district with immediate effect. Now, your lordship will see, my lord, kindly note, number 1, teacher will be instant to release. Number 2, the teacher will take release from the present place of posting and will report to the inspector of schools of the newly posted district within 10 days from the date of issue of the order. That means, my lord, no school has been allotted. Then 3, the district level committee of the newly posted district shall allot the school to the teacher considering the PTR and other relevant criteria as per rules. 4, the teacher has to update his profile in Shiksha Setu. Then 5, this is important, my lord. The teacher shall not claim seniority over the existing staff of the newly posted school. The seniority of the teacher shall be counted in the place of posting from the date of joining in the new posted school. Now, my lord, by this order, firstly, your lordship will see, my lord, he has not been, my lord, posted against any particular school. Then, my lord, he will lose his seniority for 11 years.
Is it the transfer of your what you call the what you call
mutual request?
Mutual request? No.
No, my. That will be clear, my lord, from the next order, because based on that order, 27/11/2024 at page 20, my lord, this transfer order has been issued. This is the order issued by the, my lord, government deputy secretary. From the deputy secretary to the director of secondary education, approval of transfer proposal of Nasir Chaudhary, assistant teacher of Sonarpur High School, Kamrup. With reference to the subject cited above, I am directed to say that in pursuance to your letter number such and such dated 2011-2024 for inter-district transfer of Mr. Rashid Chaudhary as assistant teacher, Sonarpur High School, in respect of reported complaints and allegations against the said teacher, the government department of the school education in the public interest hereby accord approval towards the transfer proposal of the said teacher, and he should be transferred to a vacant post in any need-based school in the district of South Salmara Mankachar, and he should be directed to join his new place of posting immediately. Now, my lord, this is very this makes it very clear that this, my lord, this is a punitive order. If, my lord, there is any complaint against me, a proceeding can be initiated. I cannot be punished like this, more so, my lord, when I'm orthopedically, my lord, challenged. Now, your lordship will kindly see that in this order, government order, reference has been made, my lord, of the provision in the transfer order, my lord, section 5A of the my lord transfer rules. That I have annexed, my lord.
Where is that?
Because your lordship, in the earlier cases, this was not brought to your to notice, because, my lord, perhaps it was not necessary. That amendment your lordship will get at page 26.
26. Yes.
My lord, section 3. In the Principal Act, after section 5, the following new section 5A shall be inserted. Namely, the government in the school education department for administrative exigencies may transfer or shift any teacher at any time during a year for rationalization or shifting of teachers, which is done throughout the year. Now, my lord, so far this, my lord, new amendment is concerned, my lord, administrative exigency. That is the, my lord, catchword. Now, in the present school where he is serving in Sonapur, my lord, there are only 3 teachers. And my lord, total number of students is 393. So, my lord, pupil teacher ratio is also to be, my lord, taken into consideration. My learned friend in the earlier cases has, my lord, pointed out. And also the rule, my lord, the not following the rules. Here, my lord, since it is an inter-district transfer, it is the, my lord, the under the section 6, it is the state committee which will consider. Now, my lord, firstly, my submission is that, my lord, I'm a physically challenged person. I was appointed in such quota. Then, my lord, secondly, I cannot be made to lose 11 years of seniority. And number 3, my lord, that there is no public exigency, my lord. It is a punitive transfer. Therefore, my lord, my submission, humble submission is that your lordship will see this, and, my lord, let them justify. How I can be, my lord, made to lose? How can they punish me, my lord?
My lord, at this stage, my lord, notice may be issued as because some allegation is also there here, my lord. And moreover, it is stated in the letter dated 27/11/2024 in the public interest, hereby accorded approval towards the transfer proposal of the said teacher, and he should be transferred to a vacant post in any need based school in the district of South Salmara Mankachar.
What about clause 5, page 19?
Is the my lord order regarding the transfer, my lord?
Clause 5, I'm asking.
Yes. The teacher shall not claim seniority over the existing staff of the newly posted school, or the seniority of the teachers shall be counted in the new place of posting from the date of joining in the newly posted school. Regarding that, my lord, I have to take instruction. Otherwise, my lord, he is transferred at his own scale.
That's fine. But how about the seniority?
Regarding the seniority, yes, my lord.
Can you do this? Of course, when it is on his own request, I think there's a rule, there's a provision.
Yes.
No, in this transfer rules itself, my lord, rules say regarding transfer, inter-district transfer, only on the application.
Oh. So, heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Khan, learned counsel for the petition. Stop. Para. The by way of the present writ petition, the petitioner is challenging the order dated 4/12/2024, issued by the Director of Secondary Education Assam, whereby the petitioner who is serving as assistant teacher of Sonapur High School within bracket A, District Kamrup, within bracket Metro, is transferred at his own scale and pay to South Salmara, Mankajar district with immediate effect. Stop. Learned senior counsel for the petitioner submits that the petitioner is a physically challenged person and 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 is a physically challenged person. Stop. It is also submitted that by the order dated 4/12/2024, particularly clause 5, it is provided that the petitioner shall not claim seniority over the existing staff of the newly posted schools, and his seniority shall be counted in the new place of posting only from the date of joining in the said newly posted school staff. Accordingly, the petitioner is losing 11 years of his service, which is not permissible. Stop. Learned senior counsel also submits that the order dated 4/12/2024, by which the petitioner has been transferred, was on the basis of a communication dated 27/11/2024, issued by the Deputy Secretary to the Government of Assam, Department of School Education, and addressed to the Director of Secondary Education Assam, wherein it is stated that 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 there are complaints and allegations against the petitioner, and therefore in public interest, the petitioner should be transferred to a vacant post in any NEET school in the district of South Salmara, Mankacha. Stop. The same would indicate that the transfer of the petitioner is not in public interest, but punitive in nature. Stop. He therefore submits that the impugned order dated 24/4/2013 requires to be suspended.
My lord, I have also made statement in paragraph 16 that, my lord, I have not been released yet.
It is further submitted. Cancel that line. That the petitioner has not been released till date, and accordingly, the order dated 24/4/2013 is suspended at this stage. Stop. Issue notice. Mr. U. Sharma, Learned Senior Counsel, Learned Standing Counsel, Secondary Education Department, appears for the respondents 1, 2,
4, and 5, my lord.
4, and 5. State level committee.
State level committee.
Duty.
Duty.
He's fast asleep. It's not known. You want to sleep, you can go home and sleep, but not inside the courtroom. Mr. B. Deuri, learned government. Enters appearance on behalf of respondent number 3.
We are preparing your lordship for Mr. P. Nayak, SSC.
Oh, okay. You have for respondent 6.
6.
6.
Treasury officer.
You, Sharma, was for 1.
I am 1, 2, 4, and 5.
4, 5, 6. Huh? And Mr. P. Nayak, the understanding counsel, SSF, appears for the respondent number 3. And Mr. R. Barbujari, the understanding counsel, finance department, appears for the respondent number 7. Notice on respondents are complete. Respondents are allowed to file affidavit. On top, you say extra copies. List after 4 weeks. In the interim, the order dated 4/12/2024, issued by the Director of Secondary Education, Assam, transferring the petitioner to South Salwara, Mangachar district, shall remain suspended till the next.
Highly ordered.
Production list item 1.
Let me lord. My lord, petitioner before lordship, my lord, is the governing body, my lord, of Dr. Sarvapalli Radhakrishnan Teachers Training and Research Institute, my lord, Samata, my lord. That governing body was duly formed, my lord, as per the NCT guideline as well as the ordinance of the Guwahati University, my lord. And it takes effect with effect from 12/6/2023 with the extension period of 3 years, my lord, as per G ordinance, my lord. Now, what happened, my lord? This committee was challenged by the sponsoring body of the college, my lord. What? This governing body, my lord, earlier it was challenged. Constitution of this governing body was earlier challenged by the sponsoring body, my lord. That is Project Samata. My lord, they had challenged this constitution of this governing body, my lord. And accordingly, the Honorable High Court, my lord, and I am outrightly come to case 66, my lord. Yes. Your my lord, lordship kindly come to page 70, my lord. Here, my lord. Page 70, my lord. Till the next date, status quo as regard to the constitution of the governing body shall be maintained, my lord. Now, my lord.
1 minute.
This was filed by the sponsoring body, my lord, namely Project Samata Educational Society, my lord. They have challenged the governing body of the, my lord.
So there's no governing body as of
No,
now?
the existing governing body is there, my lord.
Oh.
This governing body is still working, my lord. Now, my lord, while this order is still in force, my lord, because the restriction is pending, my lord. Now, this sponsoring body, my lord, they have invited a meeting, my lord, tomorrow, my lord. That to be held tomorrow, my lord, case 81, my lord. I have impugned that notification, my lord. Now, my lord, since the governing body has already been immune, my lord, by this Honorable High Court, now they have always again taken a meeting to be held tomorrow, my lord. Kindly come to page 82, my lord. They have kept two agenda, my lord. Agenda number 3, my lord. Discussion and decision regarding the principal acting illegally. Number 4, my can see discussion and decision regarding the present governing body of the Dr. Sarvapalli Radhakrishnan Teachers Education and Research Institute. My lord, since this governing body had already been directed to maintain status quo, my lord. Now, my lord, how this sponsoring body, my lord, can take decision, my lord.
1 minute.
Now, it's supposed to be held tomorrow, my lord. Now, my prayer is that, my lord, whatever they want to do, my lord, they can do, my lord. My prayer is that they should not act it and on the agenda number 3 and 4, my lord. Because it pertains to, my lord, governing body, my lord. And governing body has already made immune by this honorable court, my lord. And there are some other grounds, my lord.
1 minute. Yes, have you served copy?
My lord.
Huh?
My lord.
Who are the respondents?
My lord, respondent, my lord, education department is also there, my lord. And education department is also there, my lord. Private respondents are also there, my lord.
Guwahati University?
Yes, madam.
Have you served copy?
Yes, madam. We have served copy. Yeah.
Where are they?
Right now, my lord, I don't know, my lord, whether they are aware of this.
Just check out whether the copy has been sent.
They are, my lord. Now, my lord, my prayer is there, my lord. Now, see, it is so.
And see, where's the Guwahati University? Get hold of the Guwahati University Council.
Education department also there, my lord. Now, my lord, even lordship wants some clarification, my lord. It finally come to page 50, my lord. Page 50, my lord, point 7, my lord. The tenure of the governing body shall be 3 years from the date of
Page
50, my lord. 50, my lord. Point 8, my lord. The terms of the governing body shall be 3 years from the date of nomination of the representative of the university, my lord. Now come to page, my lord. The nomination of the university, my lord, it takes effect, my lord. Page 65, my lord. This is the Guwahati University, my lord. And from the issuance of the date, my lord, that committee, the governing body, my lord, taken effect, my lord. It is 12/6/2023, my lord. Now, 3 years, my lord, will be ended by, my lord, you know, 12/6/2026, my lord. This committee will exactly continue, my lord, governing body. 11/6.
Why did the respondent number 6 file the writ petition?
My lord, they had challenged the constitution of the governing body, my lord. That governing body, as per strictly as per ordinance of the Guwahati University, that governing body was formed, my lord. Now they were not satisfied, my lord. They wanted to take over the college, my lord.
Then what is the interim order?
That interim order, my lord, here, my lord, kindly see, my lord. The status quo was yet to be maintained, my lord. Page 70, my lord. And that repetition filed by that respondent, my lord, it is still pending, my lord.
This is pending.
Yes, my lord.
And where is the agenda for tomorrow's meeting?
The agenda, my lord, page 81, my lord. And agenda we will find it, your lordship will find at page 82, my lord. Now, the present governing body, my lord, the petitioner is active by the agenda number 3 and 4, my lord. Because they can take any decision, my lord, and they will circulate among the people, my lord, to confuse them, my lord. And it is a reputed institution, my lord. B.Ed college, my lord, it is led by the renowned educationist person, my lord. So it definitely will harm the reputation of the college, my lord. So since they are in the habit, my lord, of filing cases, my lord, so my lord, petitioner at the genuine grievance, my lord, they can take any decision, my lord. Now, my lord, since they have not yet, meeting is yet to be held tomorrow, my lord. So my simple prayer is that, my lord, whatever they take, if any decision taken on the agenda number 3 and 4, my lord, that may be met subject to the outcome of the petition, my lord. In the meantime, we will take steps, my lord.
Where are the other respondents? Guwahati University.
Education department has taken it. Guwahati University. We have not received many copies. Guwahati University. Huh? This is the copy. This is the.
Well, Lordship, we have not informed that today
We
this
serve a copy.
case will be.
We'll take up after some time.
Yeah.
On the other respondents, education department,
We have already served. Item 15 and 16. Admission.
My lord, this matter may be taken up some other day, my lord.
No,
because-
my lord, I have the urgency, my lord.
But by
Yeah,
mistakenly,
but
I did not bring the file, my lord. Misplaced, my lord. Any day, some other day, my lord.
My lord, let's see, my IA for modification of the interim order, my lord. Every day, my lord, this is going on, day
What
after
every
day.
day?
For more than 1.5 years, my lord, this IA under 226(3) is pending. Lordship may decide.
what I'll do, I'll fix a date on the opening day of the court.
Yes.
On that day, there will be no adjournment.
Mine.
We'll
That will be okay.
hear
Mine.
this one.
Otherwise, my lord, if he prays for adjournment, my lord, my IA may be considered.
Yeah. Okay. On
I have to
request made
misplace
by
it,
Jaya Bharbuya, learned
doing?
counsel for the petitioner, list the matter on 6th of January 2025.
Instead of 6, my lord, some other day later, my lord.
My lord. This is going on, my lord.
No, no,
Lordship kindly see earlier
Instead of
orders.
my
my lord.
lordship
Every day
can
he's
fix
taking
the matter
adjournment.
on 8, my.
8.
6 is the Friday,
Opening day.
Opening day, my lord, it will be.
next day, my lord, 8 or
Then 7, my lord. It's a hearing.
62
It may
cases.
accommodate.
8 if your lordship is convenient.
It will be a motion day, my lord.
Okay. 8 will fix on 8th of January. It is made clear there shall be no adjournment on the next date.
And when in the admission column, the matter will be in the top, my lord.
Let it come.
Item 17 to 19.
The repetition, writ appeal is there, similar cases, so let the matter be listed after completion of the writ
4
appeal.
weeks
Yes,
on request made by MSK.
writ appeal is fixed in the month of January.
Please, on request made by MSK Devil and the counsel for the petitioner.
First week of February, then
List the matter in the month of February.
February, yeah. Hello, like.
Item 20 and 21.
My lord, the matter may be taken up after vacation. My senior has some personal difficulties to.
Who's your senior?
MJ Gadir, my lord.
On request made on behalf of Mr. M.J. Kadir and counsel for the petitioner, list after the winter vacation. Yeah.
Hello, my
My lord, I'm sorry, my lord. 15, 16, my lord, interim to be continued.
Okay. If you want to pass it.
Item 22.
My lord, opposite party is BTC, my lord. Let the matter be listed in the opening day, my lord. Showing the name of and her.
Chowdhury, the
This is the
BTC.
case of, my lord, what happened? This is a case of non-payment of salary. The poster holding gate 4, my lord, all the petitioners, my lord. And they have terminated me, my lord, as a teacher, my lord. Not as a gate 4, my lord. Until today, I have not received salaries, my lord. And we have been regularized after the obtaining the order of the division bench, my lord, by this honorable court. This is the case. Till today, we have not received. Lordship, pass an order to give the current salary at least.
Lordship, the supplementary demand was forwarded to the WPT department of the government.
Party, my lord.
But till now, we have not received any.
Have you filed your affidavit?
Yes.
No.
No,
Lordship.
nothing, my lord.
Lordship, may allow me.
21.
Short.
In the year 2021.
I'll try to get the
How
up-to-date
unfortunate,
status.
my lord.
Up
They
to
were
date
holding the gate 4, my lord. They have not been paid, my lord. And they have been regularized after the passing these orders of this honorable court. That to writ appeal, my lord.
Hurt MSK Devil and the counsel for the petitioner. On request made by B. Chowdhury and the standing counsel BTC, 2 weeks time is allowed to
The
file.
date may be fixed.
Is allowed to file affidavit. List on, when do you want, after Bihu? After Bihu or
Yes.
before Bihu?
Before Bihu, better, my lord.
But
Because
then 1 week, many
yes,
cases.
yes, my lord. Yes, my lord.
After
After
Bihu.
Bihu, after Bihu.
22nd.
Showing the name of and her, my lord, WT. Adhar, not N, no?
Huh?
Changing the name of Arthur.
is also directed to
Yes,
reflect the
exactly.
name of Mr. Arthur, then a standing council. Which department?
Earlier WBT, now it has been changed as a KTSL. Huh? Huh? Welfare
No, the WBT.
Welfare Department, Bodoland Territory. Welfare Department, my lord. I have made party.
It's not a party here.
Party, my lord. I have filed IA. The IA order is there.
IA?
Dispose of, yes, my lord. That is 2841/2024. Dispose of on 38/9/2024.
No.
You file your
Is
amended
to
cost
amended,
title?
yes, yes, my lord.
What's the amended cost title?
I have filed, my lord. Otherwise, the case will not be listed if I will not make file case, application.
Where is the IA? Where is the cost? Okay, okay.
I number 2, man. I 2841, no? 2024. Whatever. Amendment to code. Number 222.
Then Arthur, standing council, which
Yes.
department?
Bowland Welfare.
Rural Welfare Department.
Okay.
Highly obliged.
23.
11 of delay, no? January ki month.
Here also, my lord, BTC is yet to file their affidavit by Raspona number 2. And against affidavit opposition filed by the Raspona 5, we will file the my lord, reply. So can it be, my lord, on reopening so that they can file their affidavit? Otherwise, it will be.
Yes, okay, heard Mr.
UK Goswami.
Goswami, learned counsel for the petitioner. On request made by B. Chowdhury, and standing counsel BTC. 2 weeks. Yes. Time is allowed to file counter affidavit. This the matter on. Okay. 22nd January.
Please, your lordship. Lordship, same and similar subject matter has been pending in WPC 4652 public 2023. Maybe tagged with
Along with WBC number
4652 of 2023.
4652.
4652.
24.
Kindly peruse the order dated 22/11, my lord. Mr. A. Fukon Malat appearing and submits that Malat instruction receipt and seeking time to file affidavit, Malat.
No counter.
No affidavit, Malat.
Where's Fukan?
A. Fukon.
Elementary. Who appears for elementary? Yes, Kaushik, you have received instructions and you are allowed to file affidavit.
Item 24.
Lordship will give us some time, my lord. Possibly, my lord, Mr. Fikon has received the instruction, my lord. He was supposed to file.
Okay, but Mr. Patkari, learning counsel for the petitioner on request made on behalf of Mr. A. Fukan, the standing counsel element education department. 2 weeks for the time is allowed to file counter affidavit. Please.
25.
My lord, here petitioner is the first wife of late Bokromari Borhuya. But the respondent number 9, who is the second wife, she is receiving the pension matters, pension money. So we have filed this suit for the purpose that, as per the full bench judgment of our High Court, the first wife is entitled to get the pension. Of course, second wife may have some rights. She may file petition for proportional share, but first it will go to the first wife.
My lord, my submission, my lord, the first wife is no longer become wife. She was divorced on, my lord, in the year 2020, 14, 12, 2020, my lord. So after, and then I am the only legally married wife, my lord. So in the office record, my lord, no record was sent that she is in wife.
So you have an interim protection.
Yes.
Have you filed your affidavit?
I will file, my lord. There is urgency because since May, the pension is stopped, my lord. So on 19.
You are saying there's urgency, you don't file affidavit.
Yes,
What is
I
this?
will file, my lord. Kindly fixed on 19, my lord. On Tuesday, I will file affidavit.
19th?
19 of
This,
December.
this week?
December, my lord.
This is a motion week only, next week. Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Mr. H.R. Chowdhury, learned counsel appearing for the respond number 9 is allowed 1 week time. 1 week time to file counter affidavit. Praise allowed, list after 1 week. Interim order passed in the IA shall continue till the next date. Okay, on top, just Mr. D. Bhattacharya, standing counsel appears for the accountant general.
26.
And Mr. R. Babu, finance. Standing counsel, finance appears for respond number 7. Yes.
Your Lordship, this matter is about the accommodation of the post of assistant teacher. And we were asked to file an affidavit regarding to show the appointment of teachers who were similarly with the same qualifications. Then, Your Lordship, the government party was asked to file an affidavit to show.
Elementary, who is appearing for elementary? You're given a last chance.
Probably, well, N. Fukon was there.
I don't know who was there, but you are representing the elementary education department.
Further, my lord, some time may be granted, my lord.
If you don't file it next time, then we'll proceed on the basis of materials available on the court. Part MS?
SD.
SD and a counsel for the petition. On request made by Mr. B.K. Boral and standing counsel elementary education department. 3 weeks further time is allowed to file counter affidavit as last chance. It is made clear that if by the next returnable date, if no affidavit is filed, this case shall proceed on the basis of materials available on record.
Published 27.
After 3 weeks.
Here also, on last occasion, we are submitted a affidavit filed. Due to some.
You submitted that you have received instructions.
Yes,
then
on last occasion, my colleague P.N. Sharma was appeared, madam. Kindly fix after immediately after vacation, madam. File everything.
Okay, none appears for the on request made by J. Bekul and the standing counsel elementary education department. 3 weeks for the time is allowed to file contract.
Obliged.
28.
As you return my pension paper, madam, page 85, madam. You see? In them, I am not also not getting my provisional pension, madam. As per the last order, madam, the instruction was sought for, madam.
Yes, with regard to provisional pension, finance.
The provisional pension.
And SCRT.
Lordship, from SCRT, I have not received any instruction, Lordship, short time maybe.
See, if the petitioner.
31st of January 2023, he retired, my lord.
So far as my lord, payment of provisional pension is concerned, finance department is not related at all.
That's fine. That's
Now-
why I'm asking the
Yes,
SCRT
yes.
department.
Now, on the whole matter, my lord, we have received a parawise summons. We will be filing an affidavit, my lord. But so far as that aspect of the matter, my lord, it is within the domain of the administration.
Okay, heard Mr. S. Waterfall, Learned Counsel. Mr. R. Babujari, Learned Standing Counsel, Finance Department, submits he has received instructions. How much time you require?
My lord, 2 weeks, my lord.
And prays for 2 weeks time to receive instructions. Stop. Para. Mr. B. Chowdhury, Learned Standing Counsel, SCRT. Similarly prays for 2 weeks time to enable him to receive instructions with regard to the provisional pension claimed by the petitioner.
No, I'm claiming, my lord, but my final pension was not finalized, my lord.
No, that's
In the
fine.
meantime, my lord, the provisional pension may be paid, my lord.
Claimed by the petitioner. Prayers allowed. List after 2 weeks.
But date time fixed, my lord, the pension, my lord.
Very difficult to fix. 20 January.
Before that, can I?
Otherwise, yeah, Bihu is there before then 1 week only.
29.
Obliged, my lord.
Let me know. Well, matter pertains to non-payment of my lord's pensionary benefit and other service benefits to the wife, my lord. And already husband of the petitioner died in 2022, my lord.
What is
Nothing
the
has been-
respondent number 8?
For phone number 8, we need some time to file our application.
And the other respondents?
No, let me.
Duty? Pension department is the main department, isn't it?
My lord. So for pension is concerned, other my lord service benefit like my lord GPF, GIS, leave said nothing has been paid, my lord. For last 2 years, my lord. Lordship at least stage my lord, directly my lord, respondents at least to my lord release one portion, my lord, either GPF or leave salary, my lord. At least to survive, my lord.
Who's supposed to pay that?
By the department, my lord.
Secretary?
My lord.
Will give us 2 weeks time.
Person is retired, GPF, GIS, leave salary, nothing released. What is going on?
There's a dispute with regard to the next of kin, my lord.
Mother is not entitled to, my lord, under the law, my lord, under the
And there
pension.
was 2 next of kin certificates
Okay.
submitted, my lord.
Heard Mr. PJ Saike, Learned Counsel for the petition. Mr. B. Kaushik, Learned Standing Counsel,
Secondary education.
Secondary Education. And Mr. B. Deuri, Learned Government Advocate, appearing for the respondent number 3 and 6, prays for 2 weeks time
Hello.
to file the respective affidavits. Para. Similar prayers made by Mr. A. Learned Counsel for the respondent number 8. Prayers allowed. List after 2 weeks.
My lord. My lord, observation may be if next date, my lord, no affidavit has been filed, my lord, and my necessary order may be passed.
Yeah, that will consider.
Otherwise, my lord, it is difficult for living, my lord.
Mr. So appears for the accountant general.
That observation may be, my lord, made.
Okay, by the next date, if no affidavit is filed by the respondents, appropriate order shall be passed by the court.
Obliged, lord. I'll serve.
Item 30.
I need some time, man. On last petition, I put in some instruction.
At mutual transfer matter, your lordship has already disposed of 3 petitions. And this is
Immediately
regarding
after
purpose.
vacation, man, I'll be in the.
Okay. Just an interim here?
No, lordship. Show cause, yes, Lordship, there is an interim order.
This is a show cause, isn't it?
Yes, Lordship. Show cause was stayed while issuing notice, Lordship. 27/5/2024.
MSR Chowdhury, London Council, petition on request made by PK Boral and the Standing Council Elementary Education Department. How much time?
My lord, on 10th of January.
List the matter on when?
He's asking for 10th of January. Can it be on Lordship 18th of January, Lordship, in the after reopening? Or
18th is a Saturday. On
22, my lord.
oh, it's 24th.
22nd, no,
20.
24th, 24th January.
24th of that.
Obliged, my lord.
It's a motor procedure to
Interim.
continue.
Obliged, Lordship.
Item 31. I'm sorry, my lord. I think in item number 27, my lord. I was in another code, my lord. It's for non-appeal, my lord. Our name may be
Item
27, my lord. 27.
what, Mr.
AK Azad.
Okay. Then
Oh,
after that,
obliged.
same order you come. Except that non-appeals, you can select.
In this my lord, 31, my lord, the affidavit has steady, my lord. We are filing it on Monday, my lord.
My lord, they are filing by Monday, then it may be on Tuesday, my lord. Because, my lord, your lordship would be pleased to see order dated 18/9/2024. That interim order will be considered in the next date, that is on 25/10/2024. Thereafter, my lord, on 25/10/2024, again they have taken time.
Okay.
And your lordship, every time,
Number 4, and I have filed my affidavit on the last occasion. They took time to file reply. They have not filed it today.
my lord, regarding respondent number 5, we have no clash, my lord. It is with the government only,
Respondent 4.
my lord. I have no clash with the
Let me check.
respondent.
London Council
No,
for the
That
petition.
may be recorded.
Okay, stop. Mr. P. Kaushik, London Standing Council, Secondary Education Department, submits that they will be filing counter affidavit on or before 16th of December 2024. Stop. Accordingly, list the matter on 3rd of January.
Obligation.
I for respond number 4, my.
Mr. A. Hassan, then the council appears for this.
32.
May it please your lordship. Your lordship has already heard this matter last occasion. It relates to moot point here.
NCT has come with the affidavit.
No affidavit has been filed, my lord.
Last occasion, I alarm 100 times. That's why we allowed, because that affidavit was required.
I alarm code.
Where's I alarm?
Alarm code. He is the standing council, NCT. Last time he took my lord time for
That's why
filing affidavit.
that affidavit is required. That's why we said he was allowed 2 weeks time.
Since we have sent a communication regarding the status of this college, so his
Just
tenant
since you junior to get I alarm, we'll pick up after some time. Let I alarm come.
33. Item 33.
Non appears for the petitioner. List after 3 weeks. In the meantime, respondents are allowed to file the counter.
34.
But in fact, we have a short issue in this case. Regarding lordship, they have filed an affidavit making contradiction of their own document. paragraph 4 of the affidavit, your lordship may kindly see. We are paragraph 4 of the affidavit in opposition. They are saying, lordship, that percentage of pass out student has been calculated on the basis of admit card issued to the candidate.
1 minute. Which is there are two affidavit.
Filed by respondent number 5, my lord.
Okay.
Page 53, my lord. Paragraph 4.
Yes.
Paragraph page 53, paragraph 4, lordship.
Yes.
Which is contrary to their own documents, lordship, page 24 of the petition, lordship. Well, there is a requirement that
1 minute.
page 24. This is the result pertaining to 2014 lordship. 2015 and 16, we have lordship comply to it. Paragraph page 24, your lordship will find applied candidate. Number of applied candidate is given in respect of male, female, and total number is given. And in the right side, lordship, appeared candidate. So number of appeared candidates is less than number of applied candidate. And lordship, your lordship will find in the right side, first division, second division, third division, these are the categories of candidate passed out. And percentage, pass percentage is given 65.33. Well, these percentage has been, lordship, they have calculated on the basis of appeared candidates, not on the basis of applied candidate. Because there may be, lordship, applied candidate may be, lordship, suppose 100. And appeared candidate may be 30 or
In general, this has been shown, my lord, but board never provide percentage of a particular school. Only the enrolled candidate and numbers of candidate passed out. That must provided.
This is the criteria that they are following, lordship. On the basis of the, lordship, appeared candidate, pass percentage is to be calculated. They are saying that, lordship, that on the basis of, lordship, number of admit card issued in respect of the candidate. A candidate can apply for examination. He may not appear. He may not appear, lordship. Suppose 100 students applied for appearing in the examination. 80 students appeared. So number of percentage, lordship, percentage is to be calculated on the basis of appeared candidates. That's 80, not on the basis of 100 candidates, because 20 students did not appear. So they cannot come within the purview of, lordship, percentage and pass.
No, what you are saying is it's calculated on the basis of admit card issued.
Yes, they are saying.
Enroll candidate, my lord.
My lord, this is contrary with their own document.
But there two candidate were absent, my lord. They are claiming they.
Then what about this page 24?
My lord, this is the result gazette, my lord. Wherein in the above of the result gazette, my lord, this has been shown that numbers of candidates appeared, passed out, and total percentage, my lord. Just to show a performance of that particular year, my lord. But not provided percentage of a particular school, my lord.
How can they, lordship, determine on the basis of applied candidate? Some candidate did not
Oh, it
appear.
says high school leaving certificate examination.
Yes. In respect of 2014, 15, and 16, we have to pass a lordship the student is.
No.
This is abstract of results, my lord.
This is abstract of result.
Abstract of result. This is not this is not pertaining to one particular school.
Yes, my
No, no.
As
This
a
is for
in general.
general.
Yes.
So accordingly, lordship, here lordship, the Provincialization Act requires that 30% of the student must come out from the examination. In respect of last three examination, two examination, 15 and 16, 2015 and 16, we have lordship come out with more than 30%. And so far 2014 is concerned, 56 candidate applied, 54 candidate appeared in the examination. Now, lordship, the SEBA as well as the Department of the Education, they are calculating the percentage on the basis of applied candidate, that is 56. Enroll candidate.
No, on what basis? What are you banging on page 24?
Yes, page 24, lordship, this indicate that the percentage of pass candidate is determined on the basis of applied candidate, not on the basis of applied candidate. So this percentage, lordship, they have calculated. I have, lordship, done through that calculation, and calculation is based on the appeared candidate, not on the basis of applied candidate. Why, if the, lordship, percentage of pass student is calculated on the basis of appeared candidate, in respect
Where's
of
the percentage of your school?
My lord, yes. Your lordship will find. Your lordship will find page 29. There is no question, lordship, in respect of 15 and 16. Lordship, director has also applied, that is page 28, lordship, just before 29. The director has sought for information from the SEBA regarding applied candidate, appeared candidate, and pass out candidate, that is page 28. But the SEBA has given information, lordship, missing that appeared candidate. Page 29.
My lord, here, my lord, in the column, my lord, year of HLC examination, number of candidate 56, number of candidate passed are 16.
Issue is relating to first one, lordship, 2024. They are not denying that all 56, they are not saying that all 56 candidates appear in the examination. Lordship, the two candidates who did not appear.
No, see, this page 28.
My lord.
This is written by the director.
Yes.
Correct.
Correct.
And in this, it says to give information regarding enrollment, number of students appeared
in the final examination.
All right.
But what they have given, your lordship will say, in respect of number of candidates is given, number of appeared candidates is not given. Their lordship created all this problem, lordship.
Okay. Only the number of candidates passed. That has been given.
That yes, no, they have given, lordship, number of candidate enrolled, that is 56.
Oh.
But we are saying that director also said in that letter, number of appeared candidate also.
Oh.
That has not been provided till date.
That is what the director is asking for.
Yes, ma'am.
Page 28.
28, my lord.
This is the number of enrolled.
Yes, my lord. Here only number of candidates shown, my lord.
See here, what the director is saying is regarding enrollment.
Yes, my lord.
And number of students appeared.
Yes.
Not passed.
Passed.
But then now what you have given is number of candidates.
Yes, ma'am.
And number of candidates passed.
Yes, my lord.
Not the number of candidates who appeared.
Yes, my lord. Yes, my lord. Then, my lord,
your lordship,
short that may be given, my lord. I will clarify.
Okay.
Page 22, lordship, that document has clarified that 56 and 54 appear. Page 22.
Yeah. Heard M. Khan, Learning Council for Petition on request made by DP Roy, Standing Council Seva.
And now, my lord, ASSEB, my lord, Assam State School Education Board.
ASSEB,
ASSEB, my lord.
ASSEB. Huh? When do you want? After the vacation?
After vacation, my lord.
Date may be given, lordship.
List on. Okay. 20 January.
I'm appearing for 1, 2, 3, and 4.
MS Does the Standing Council
Second.
appears for the secondary education.
Public.
Item 32.
Alarm, last time we required you to file it.
Yes, my lord. After Bihu, my lord.
What after Bihu, after Bihu?
After the time like post of they will send it by post, my lord. So it will take 10 to 12 days, my lord.
Anyway, my
After that, my lord, I will file it, my lord. Normally, they will send me from New Delhi to Guwahati, my lord, by post, my lord. Speed post, my lord. So it will 10 days all day.
Let him take time, my lord. But I will pray your lordship to give some interim protection to me. That's all.
What protection do you?
One protection is that your lordship will kindly go to page 23. As your lordship knows that NTC is the body which controls the B.Ed and this teachers' education. And they have allowed us to start the college. This is the document by which National Commission for Teacher Education has allowed us to start B.Ed 2 years course and B.EL.ED elementary education 2 years course. Paragraph 2. And whereas on the scrutiny of the application submitted by the institution, the document attached therewith, the affidavit submitted and the report received from VT and the so-and-so and certificate received from the affiliated body, the committee is satisfied that the applicant fulfills the requirement under the provisions of NCTE Act and rules and relevant regulations, including norms and standards of the state teachers education program, such as structural facilities, infrastructural facilities, financial sources, etc., for running the program. Now, therefore, it is in exercise of the power under section 14(3)(c) of the NCT Act 1993, and Eastern Region Council NCT hereby grants recognition, permission to so-and-so college, this is our college, for conducting the below mentioned program for the academic year 1920 under the clause 7 of the within bracket 16th of the NCT regulation 14, subject to fulfillment of the other conditions. So B.Ed 100 students and B.EL.ED for 50 students. So we have, on the basis of that, my lord, we have your lordship will kindly go to page page 12, my lord, our statement at page 19. Paragraph 19. That no so-called notice or opportunity of being heard was given to the petitioner college before deleting the name from the list of affiliation for which the petitioner college cannot give admission to the next year classes, that is 24-25 academic year, jeopardizing the interest of the future of 100 students who completed the part of their studies in the sudden deletion of the petitioner's college from the list affiliated college dated 8881. That was the Interim notification. The GU authority acted arbitrarily and without jurisdiction to delete the name of the petitioners, recognizing the when it has already been received recognition from the NCTE. The rule requires prior approval from the NCTE for deletion of the
Senior
name.
Counsel, what type of interim order do you want?
Now, my lord, your lordship will see page 20, page 13, page para 20. That it is unfortunate to note that the affiliation authority had withdrawn affiliation of the petitioners college at a time when the admission to the next session ends at 28 August 2024. Therefore, there remains only about 10 days and the putting the fate of the about 100 students who has completed the earlier session of 23-24. Now, under these circumstances, the future of the students is jeopardized by the arbitrary action of the university, that too without having jurisdiction to and violating of the rules of the national justice. Thus, an emergent situation arose as a result of which notification dated 8/8/2008, and for the interest of future, the students who have completed their courses and so this is for entirely for the interest of the teachers. Now, my lord, they say that it is not deaffiliated. They have said that kept in abeyance the affiliation granted earlier. So, my lord, my humble petition submission is there. Let them file the affidavit or anything they like. But in the meantime, this notification by which the affiliation, this is, I have annexed it as page 59, my lord.
Yes.
This is the by which it is resolved that B.Ed courses offered by Hamak Rural College of Education, Nagaon, be kept in abeyance till following conditions are fulfilled. So it is not the absolute one. They have advised us to do something.
Have you fulfilled all these conditions?
Yes, we have
That's what we want to know.
yeah. So that
at
we have
least,
completed. That we have
No, our
completed.
stand is clear, my lord. Those conditions not at all been fulfilled.
That's why
And this kept in abeyance order is not under silence.
Mr. A.C. Bora Guhan, learned counsel for the petition, learned senior counsel.
But one thing, your lordship will
R. Singh. Learned
one
counsel.
thing, my lord. This is a central act. Neither the state government nor the university has any power to doctor this act and give some new condition there. So that has been, I have placed before your lordship.
See, one thing what I'm planning to do. I'm giving NCT a very short period of time. On the opening day, on the 3rd, we'll list this matter. Make sure you file it and we dispose of. On request made by Mr. I. Alam, London Standing Council NCT, 2 weeks further time is allowed to file counter affidavit. The matter on 3rd of January 2025. On which date an attempt shall be made to dispose of this report.
Only prayer, my lord. The admission may not be affected during before these students.
Let you wait up to 3rd. On 3rd, we'll consider that prayer.
Your lordship has given as a last chance. Otherwise, my lord, every day
time as last chance.
Most of them. In fact, our affidavit is required, my lord, because we will clarify that, my lord.
That's why we are from the beginning.
No, you will have to support us, not him.
No,
because we are
NCT is a
I am not supporting, my lord, but I
neutral
am-
body.
because we are supporting your provisions.
Just clarify the stand, my lord, of the
Yes.
affidavit.
You do not support, I know.
Production list item 1.
Before starting my fan losing, the party who has added here is we are not the proper party losing. Or necessary party also. That's number 1 and 2 losing. Otherwise, one thing also they are losing when my friend or other colleague has mentioned for production list, they have to inform the other side. Just now, one brother has called me that one higher education matter is listed before this court. I have left another court and come here. This is not the proper way to file this petition.
Sorry for that.
Did you mention that in the
Yes, sir.
morning?
I should have informed you. I am there.
Nothing was done. This is not the way to file a case for production list.
Okay, yeah.
Otherwise, no. Respondent 1 and 2 have nothing to do. They have to edit SCERT as a party lawsuit. And NCT is a party, they have relied on NCT. Otherwise, SCERT is a necessary party lawsuit. We have no rule. Higher education, we have no rule.
Well, basically means on the matter against the private respondent. Well, otherwise, matter everything. Neither we are challenging any action of the university or NCT. Matter basic grievance matter on the private respondent. Matter who had short meeting to be held tomorrow, my lord, and take decision, my lord, on the governing body of the college, my lord, which has already been protected by the honorable court, my lord, in another repetition, my lord.
No, that's why this protection which you are claiming that you have been protected
Yes,
at
my lord.
page 70.
Yes, my lord. The constitution of the governing body, my lord. The governing body has already been constituted, my lord. And that is duly constituted. I have already annexed all things, my lord. Kindly come to page 65, my lord.
1 minute.
My lord, when the matter is sub judice, my lord, how a private entity, my lord, can it take time?
Yes.
Basically internal matter of that.
Yeah, internal matter only. Okay, heard Mr. S. Haq, then counsel for the petitioner. Para. The respondent number 6, oblique the project Chamata Educational Society, comma, village and post office Chamata, Nalbari district, as with petitioners, filed WBC number
5089 of 2023, my lord.
5089 of 2023. Taking a ground that the existing governing body of Dr. Sarvapalli Radhakrishnan Teachers Training and Research Institute, Chamata, has been reconstituted, and the response number 6 oblique with petitioner was not informed by the respondent authorities in any manner as to which authority had reconstituted and in what manner it has been reconstituted. Stop. Accordingly, after hearing the parties, this court passed an interim order directing
on 7/9/20.
Passed an interim order on 7/9/2023, directing to maintain status quo as regards the constitution of the governing body of the said institute. Stop. Para. The present writ petition has been filed by the
Public notice, my lord.
governing body of Dr. Sarvepalli Radhakrishnan Teachers Training and Research Institute, challenging the agenda number 4.
3 and 4.
3 and 4.
My lord. 3 is the principal also, my lord, included. Principal is also principal is also part of the governing body. Ultimately, 4 will cover, my lord.
Only 4 will do. 3 I'm not interfering with you. Challenging agenda number 4 of the 8th biennial meeting of the Project Chamata Educational Society, scheduled to be held on 14/12/2024, on the ground that as there is already an order of status quo in WBC number
5089 of 23. 5089 of
5089 of 2023. The agenda number 4, within inverted commas, discussion and decision regarding the present governing body of the Dr. Sarvili Radhakrishnan Teachers Education and Research Institution, comma, close inverted comma, cannot be considered in the said 8th biennial meeting of Project Chamata Educational Society. So, issue notice. Mr. K. Gogoi, and Standing Council, Higher Education,
indicate our submission Lordship. We are not necessary
appears on behalf of the respondents 1 and 2 and submits that the Higher Education Department is not the necessary party. And in fact, it is the SCRT and the
SCRT and the NCT is
and the NCT
is a
who should
necessary
be-
party.
who are necessary parties. Stop. Para. Mr. PG Fukan, the Standing Council, Guwahati University, appears for the respond number 3.
3.
And Mr. Government,
Theory is the P theory.
Mr. B. Deori, and the government, it appears for the respondents 4 and 5. Is this 4 and 5? Just check out.
4 and 5 Lordship.
Appears for the respondent. Petitioner to take steps for service of notice on the respondents 6 and 7 by registered post AD within 1 week from today. List after 4 weeks. In the interim, comma. Agenda number 4. Within inverted commas, you say discussion and decision regarding the present governing body of Dr. So and so, Education Research Institution. Page 82, you'll see it. Shall remain suspended. Agenda, to be discussed in the 8th biennial meeting of Project Samata Educational Society to be held on 14/12/2024 shall remain suspended till the next meeting.
I am obliged.
Agenda
The IA is there, with
What is this IA about?
we will sincerely pray to withdraw the affidavit filed by the UGC on 28th of February 2024. There were some mistakes, my lord, and we want to withdraw it and we'd like to file a fresh if your lordship permits.
Yes.
My lord, in this case, my humble submission before this honorable court, UGC relating to degree has no any authority to say whether the candidate's degree is valid or not. UGC's function is this only making rule, framing rule, and approve the university. It is the
Mr. Ahmed,
my lord.
are you objecting to the withdrawal of the affidavit?
My lord,
Heard Mr. H. Amal and the council and the standing council, UGC for the applicants in the IA. Huh? Also heard Mr. K.U. Ahmed
my lord.
and the council for the opposite party number
1.
Oblique fifth petitioner. Mr. K. Gogoi, and the standing council higher education for the opposite parties 2 and 3. Anybody governing body? And Mr. S.K. Das, then the council for the opposite party number 5. Stop. By this application, the applicants, the applicant, who is represented by the secretary, University Grants Commission, is praying for withdrawal of the counter affidavit filed on 28/2/2024 on the ground that what was the ground?
with some revised scrutiny, some mistakes have crept in, my lord. We have
On the ground that some mistakes have crept in the state counter affidavit. And stop. For when counsel for the opposing parties has no objection. But this court has also considered the question in the present application in its certificate. And accordingly, the applicants are permitted to withdraw the counter affidavit filed on 28th. For in the main requisition, in view of the order passed to be an I number 2, the applicants are permitted to withdraw the counter affidavit. No, the applicants, not the applicant,
to file a fresh affidavit.
no, respondent number.
In the main suit, you are respondent, my lord.
5, my lord.
5.
The respondent number 5 is permitted to withdraw the counter affidavit filed on
28th February.
28 to 2023. 2024.
Yes.
Yes, my lord.
Mr. Chama, learned standing counsel UGC, prays for how much time?
We can file it day after tomorrow.
Prays for
On Monday.
prays for which time we file counter affidavit. Prays allowed. This after 1 week.
Date be fixed.
It will come up. I'm not fixing dates before the vacation.
New Year, my lord.
Automatically, it will
In
come
case of emergency, you can make a mention.
Well,
69.
my lord, regarding 68, my lord. In this case also,
Oh, item 68.
it is the tag matter, my lord.
Item 68. This the matter of the
Item 69.
May I plead your lordship? The matter pertains to drop teacher. The petitioners were dropped out of provincialization, your lordship. Lordship will kindly peruse order dated 14/11/2022.
Yes, thus.
Your Lordship, in this matter, Your Lordship, D. Kaushik is appearing. So I'm praying for matter may pass over for time being, Your Lordship. He's coming. He's on.
Lordship, may I pray, this is a 2022 matter, your lordship.
Time being quick.
Under similar circumstances, your lordship has passed order, your lordship. I have the copy of the order. On may I pray that on similar term, this petition may be disposed of?
Okay, let Kaushik come.
Yes, your lordship.
Deeply obliged.
Item 70.
May I please allow? My lord, here I need some time, my lord, we want to file an additional affidavit matter.
Well, on the last occasion, the matter was heard at length, my lordship. So your lordship has asked a query that the mark sheet, my lordship, my second mark sheet, why they have not considered it.
Yeah, true, my lord. Regarding this, my lord, we should have to submit the original mark sheet, my lord. Original HSLC mark.
That is one thing.
My lord.
And then he appeared for the second betterment examination.
Yes.
Isn't it? Why didn't you consider that? That's what
He
the
has
court
not-
wanted to know.
He has not submitted the original one, my lord. He has submitted only the 2 betterment mark sheet. That is why, my lord. My lord, that cannot be possible, my lord.
Then how
Only
they gain
one
marks
betterment
over
mark, only one betterment mark sheet will be considered, along with the original one.
Correct.
That is why we will file an affidavit, my lord, acting and document that where it is stated that.
Okay, heard Mr. S.P. Laskar and the counsel for the petitioner, Mr. P.K. Boral and the standing counsel, Elementary Education Department, is allowed 2 weeks' time to file an additional affidavit in opposition, at least after 2 weeks.
Obliged. 71.
May I please your lordship? The petitioners are the teachers of subject teacher and assistant teacher of the higher secondary school, and petitioner number 9 is a junior assistant miler, and they are praying for provincialization of their services as they are working since 2001. And the school of the petitioner was approved by the they got approval for higher secondary level, but their services was not provincialized. Even then, the number of students appeared from the beginning till date. Pass percentage is quite satisfactory, and this petitioner school is the only higher secondary school in that area. Minor, this is a tea garden area, and in this connection, the petitioner got approval, my lord, from the concerned authority, that is annexure 12, page 69. Page 69, page 71, 112, the petitioner school, Monasara Higher Secondary School. And all the petitioner having the requisite qualification, master degree, and some of them are also the BA degree holder. And in this connection, the affidavit have been filed by the respondent authority, and they are saying that the affidavit is page 92, my lord, filed by the respondent authority, and their respondent number 4 has filed the affidavit, and they are saying that in paragraph 8, page 92, the eligible teachers of existing high school with requisite qualification shall be allowed to teach in class 11 and 12 in the upgraded school. Further, the teachers of existing nearby high school, higher secondary school, senior secondary school may also allowed to teach in the proposed upgraded school. In this connection, GSC Assam will call for a feasibility report from AA, Assam Higher Secondary Education Council, before taking final decision. But here, all the teachers who were appointed by the school managing committee, and they are working since 2001, and there is no question to take the class from the nearby school, my lord, as they are working since 2001, my lord, and they have already several communication was made with the government, and the commissioner and secretary has approved the petitioner school. So and they have already filed an appeal before the higher authority to decide the matter. So, my lord,
May be pleases you.
so my point is, as they are working since last 24 years, and they have requisite qualification, and pass percentage is quite satisfactory. Also, kindly see the page where the PT the space 74. Lordship kindly peruse that 2014, 15, 16, there is a number of students appeared 105, 95, 120. Pass percentage is 50%, my lord. As they are working with that sincerity, my lord, so their service may be provincialized, and they had applied for provincialization under 2017 Act, but the inspector of
As the district scrutiny committee considered your matter.
No, my lord, because the inspector of school did not submit the relevant documents before the district scrutiny committee. That is why they were left out, my lord.
And in our affidavit in opposition also, that is on page 85, it was clearly mentioned that second line, your lordship, onwards, I would like to read. However, no recommendation from the district scrutiny committee for provincialization of the said higher secondary school has been received, which is a basic requirement as per provision of the Assam Education Provincialization Teachers and Reorganization Educational Teacher Act 2017 as amended in 2018. Here, your lordship, district scrutiny committee also did not recommend it. Recommended their name for provincialization. And thereafter, your lordship, paragraph 9 of our affidavit, that is on page 85, I would like to read that with regards to the statements made in paragraph 9 so and so, the answering deponent begs to state that in response to the later number so and so dated so and so, the inspector of school HDC Hailakandi had submitted a feasibility report regarding the upgradation of Monasira High School as per later number so and so dated so and so, which was issued by the additional secretary to the government of Assam in secondary education department wherein it is stated that there shall be no new post creation and the existing provincialized high school should have minimum 4 numbers of gradation teachers having postgraduate degree in minimum 4 core subjects for teaching in the upgraded higher secondary sections, Your Lordship. I have annexed it also as Annexure 8, which is on page 90 as Annexure A. Subject this letter has addressing to the director, Your Lordship, and the secretary also. This is the subject matter is like matter relating to upgradation of 13 number of high schools to higher secondary school and registration of the school in the portal of Assam Higher Secondary Council, where reference later date has already been mentioned, that later headed 22/10/2021. Here, Your Lordship, it was reflected that with reference to the subject cited above, I am directed to inform you that Government in Education Department is pleased to approve the list of 13 number of high school for upgradation to higher secondary in terms and condition, and a pay of the list of the school is appended herewith as Annexure A, subject to the condition that high school fulfills the following criteria. Number 1, there should not be any amalgamation proposal. Second, there should be minimum 2 additional classroom available. There must be minimum 4 number of graduate teacher having postgraduate degree in minimum 4 core subject.
Is the petitioner's school in this Annexure A?
Yes, Your Lordship. That is the further existing here, Your Lordship.
No. You have said that list
is the
of
following-
schools is appended at Annexure A.
Annexure A.
Is the petitioner school included in that Annexure A?
No, Your Lordship, because thereafter, Your Lordship, I would like to take you to Annexure B.
No.
That is on page 91.
What
Here,
what I'm saying is page 90, which is your Annexure A.
yes, sir.
And in the letter of the Additional Secretary to the Government of Assam,
Mm.
at the first paragraph, here it says that the list of schools is appended herewith at Annexure A. Is the name of the petitioner school in this list?
No.
Yes, my lord. Because there,
Where is that list?
the list is I have annexed the list, my lord.
Where's your list?
Page 71, Annexure 11, my lord. From the list start.
Annexure? 1 minute.
Okay, Annexure 12, page 69, district-wise list of 212 upgraded high school. Proposed for change the name. This, where the petitioner's school name was reflected 112, my lord. Page 71, my lord, 112, Hailakandi, Manasara High School, and Manasara Higher Secondary School. They has already have upgraded, my lord. They got approval, my lord. And thereafter they were working, and all those teachers who were working in the higher secondary.
No. This is a letter of 2022.
Hmm.
But in that letter of date 2021,
Let them,
did you get my point?
Yes, Your Lordship.
Where's that Annexure?
Logo নাই নেকি? Annexure A to দিয়া গৈছে, but listখন নাই লগোৱা. List has not been annexed here, Your Lordship.
Let the list. Let us see whether the
Because-
petitioner school is there.
Yes, Your Lordship.
From 2021, if the petitioner's name, school name is there, then
2010,
you'll have to do
2021.
it. Yeah, you'll have to proceed. You'll have to take process.
Yeah.
Then we can direct the inspector of schools to.
But here, Your Lordship, already we have stated that DSC is the, Your Lordship, first criteria, Your Lordship, from the DSC, Your Lordship, recommendation should be made, Your Lordship. Here, Your Lordship, their name has not been recommended because they have not fulfilled certain criteria. In our affidavit also, Your Lordship,
That's fine. But in this
already
2021 letter, I want to see the list. That's all.
List.
Yeah.
Since it was not annexed, Your Lordship, I would like to take instruction in this regard,
Third
Your Lordship.
premise, Bhadra Council. Stop. Para. The respondent number 4 has filed an affidavit in opposition. And in the said affidavit in opposition, a communication dated 28 October 2021, written by the Additional Secretary to the Government of Assam, Secondary Education Department, is annexed as Annexure A. Stop. In the said communication, approval 13 numbers of high schools for upgradation to higher secondary schools with terms and conditions was given, and the list of the said schools were appended at Annexure A. Stop. However, the said Annexure A is not enclosed in the affidavit in opposition filed by the respondent of the court. MS Bill does, when it's coming off the party. Shall take as well as reduce the Annexure indicated in the communication dated
22/10/21.
22/10/2021. Yeah. List after 2 weeks.
After Bihu vacation.
One after Bihu vacation, list after the no, list after 3 weeks.
Yes.
Deeply obliged.
Item 36 for orders.
Oh. Yes.
My lord, kindly peruse the last orders, my lord. Thus, several occasions they have taken time to compile.
Yeah, where's SMT Chishti?
Your Lordship, due to some personal difficulties, he has to leave left the court, Your Lordship. In break time, Your Lordship, interval time, Your Lordship. So I am praying on behalf of him, Your Lordship. Kindly matter may list after 1 week. Any date may be given, Your Lordship.
My lord, this action is purely willful and deliberate, my lord.
Okay.
Last 8 years,
We'll pass
I am waiting, my lord.
Heard Mr. Gohin on the concept on request.
Without personal appearance, my lord, it cannot be materialized.
SMT Chishti, Learned Council appearing for the respondents 4 and 5. When?
After 1 week.
After 1 week is a holiday. List
After
on
vacation.
3rd on the opening day.
Opening day.
Yes.
Can it be on 4th, Your Lordship?
4th is Saturday.
Then your Monday.
3rd. Let him come on 3rd.
Your opinion.
He has taken sufficient time. Let him come on 3rd January.
Item 40. Item 40.
None appears for the petition. List after 2 weeks.
44.
Lordship, non-compliance of the order dated 18/3/2017. Lord.
Similar pair, Your Lordship. SMT 60 appearing. On behalf.
Respond number 3.
Yes, Your Lordship.
There's a change in the respondents. Maybe you'll have to file implement application. Anyway, on Chisti's request, I'll adjourn the matter and then you heard Mr.
S. J. Sharma.
S.J. Sharma and the counsel for the petition on request made on behalf of SMT Chisti and the counsel for the respond number 3. List the matter after 2 weeks. In the meantime, you file an
45.
This case also, my lord, they did not file affidavit, my lord.
It is that same series of
Then,
content.
my lord.
Yes, who appears here also. But the Bora,
My lord.
I don't know whether the containments are still serving.
But the directions is very specific, my lord.
No, no, no. The respondents,
Okay.
1 and 2.
Pritam Soike and Sanjeev Kumar Nath is no longer, I think. So I may need some time to implement.
Mr. N. Boral and counsel for the petitioner prays for 2 weeks time.
File.
2 weeks time to file an appropriate application for implement of necessary parties. Praise allowed. Please come to 2 weeks.
46 to 49.
My lord, these petitioners are really unfortunate because of the fact that, my lord, they are having a judgment in their favor and government is doing nothing. If your lordship can see, take up this contempt case 372 2023, my lord. What happened, my lord? The issue before the learned single judge, my lord, in the writ petition was that DLED degree they obtained after a particular age was not recognized. However, that DLED degree was obtained by the petitioners before the issuance of the advertisement. But their applications was rejected that your DLED degree should have been obtained prior to the maximum age limit of the government.
Well, here we have filed review petition, my lord.
No, my lord, the review petition, they have filed in one case only.
No, my lord. Only one case we have not filed. That is item number 48, Abdul Kalam. Yeah. In other case we have filed.
No, my lord.
But listed only one case, my lord. That is item
That is
49.
not known to us, my lord. We cannot, this court was waiting for.
Is there interim in the
Nothing,
No, my lord.
nothing.
review?
Only
Some
because
time,
on the
because,
pretext.
my lord, other two matter, my lord, item 47, 46 and 47 has not been listed before the honorable court, my lord, for review, my lord. Some time may be granted, my lord.
No, my lord, since 2023, my lord, kindly appreciate this.
You are appearing in this matter?
My lord, in contempt matters, I am appearing in item number 47, my lord. In 46, my lord.
And how about the others?
Others are Mozundar appearing in 46, my lord.
Yes.
Well, may I submit? My friend will definitely apprise this honorable court on his turn. May I submit? Kindly appreciate this, my lord. Which are, my lord, sympathy or which are, my lord, open mind that why people comes to the court. My lord. These cases were filed in the year 2020. This is end of 2024. Still their fates are after having a judgment passed in the year 2021.
Where's the order? Where's the judgment?
Judgment is in page 19, Mila. It starts from page 19. The date of hearing 21/12/2021 and 21 on same date it was delivered.
Okay. What was the direction passed?
Yes. Next page, my lord. Paragraph 2, if I may read, my lord. And the relevant portion is that, my lord, if your lordship would like to see, the relevant portion is at page 26, paragraph 17, 18. The issue was, my lord.
You were disqualified in an advertisement.
Oh, I was disqualified saying that I obtained a degree, DLED degree after a particular age.
So this court that said that no, your
No.
DLED degree is
Yes, I obtained a DLED degree much prior to the issuance of the advertisement.
And your cases have to be considered as in terms of the advertisement, correct?
Yes, my lord. And my cases comes, my lord, within the parameters, because
No, so you were considered by in the advertisement or not?
No, there, after this judgment, they did nothing.
No, what is the outcome of that advertisement?
No, this advertisement was for,
Jamal, come to page 27.
yes, my lord, I'm coming. 26, 27. On the, if I can take,
Yeah. Read from page para 18.
yes, that is what. On the backdrop of the aforesaid discussion, this court is of the opinion that the petitioners have been able to make out a case for interference in exercise of power under 226. It is accordingly held that the TAT DLED qualification acquired by the petitioners prior to the requirement process has to be construed to be meeting the eligibility criteria, and therefore, while the rejection of the petitioners in the recruitment process is set aside, the case of the petitioners for appointment as assistant teachers, as per the advertisement dated so and so, shall be duly considered, and based upon their positions in the merit list, appointments to be offered expeditiously, and in many cases in any case within the outer limit of 45 days.
After
Well,
this,
while this case was pending, we were allowed to participate in the examination. The marks they have declared, which come up within the parameters of cutoff marks. Therefore, we are entitled to be appointed. So within 45 days, that verification and all other things, that official procedure, that was allowed, directed to be completed. They did nothing. That is why I am before the court in the contempt.
You were considered in terms of the advertisement, in terms of the direction passed by this
In
court?
terms of the interim orders, we are allowed to participate in the examination process. We appeared where marks were declared. We are within the parameters for selections, but we are not being appointed, even after this judgment.
Okay. Yes.
The thing is that here, the single bench who has passed this order, was in the division bench. That is why this matter has not been listed before the honorable court. So, some time may be granted.
See, according to the petitioner's counsel, after this judgment was passed, they were considered, results declared, and they come within the parameters for appointment. Correct? So now that means, in other words, you have complied with the direction passed by this court by way of considering the matter, declaring results. Now only issue that is required is giving them the appointment orders.
Yes, sir.
Now, when you have done whatever you have to do, where is the question of filing a review?
Some time may be granted, immediately after vacation, if nothing.
2 years have gone by. Highly appreciate it.
Okay, let's see what you come with proper instructions. Bora.
Well, kindly appreciate the audacity of these contemners. They have not yet filed even an affidavit to saying that we have preferred a review petition.
Heard Mr. A. Jamal and counsel for the petitions. On request made by Mr. B. K. Bora, learned counsel, appearing for respond number
Respondent number 2, my lord.
in contempt case.
Contempt case number item 47 and 48, my lord.
In contempt case number 370 of 2023. Release the matter when?
On 10th of January, my lord.
No, not 10th.
24.
We'll have it on 20 after the Bihu.
Yes,
on the opening day.
Can it be prior to that?
Prior to that, just 1 week, it's full. So many cases are listed already.
On 22, my lord.
22 January?
Wednesday.
Yes. Can it be? Well, on that day, they will not lordship would reflect that.
To
They will
anyone
not
to receive instructions. Okay.
Without fail, my lord. Lordship may reflect it because everything will be frustrated otherwise.
If no appropriate instructions are received by the next returnable date, appropriate orders shall be passed by this.
Mal, I'm obliged.
Item 69.
Instruction.
Yes.
Instruction received, your lordship. I would like to place it. He is on legs, your lordship.
Oh.
P. Kaushik is on legs. Your lordship, here is the only reason, your lordship, in paragraph 3, it is stated that.
1 minute. So you're putting the blame on the petitioners now.
Lordship, he did not apply for provincialization
Where
as
is that
per the
order?
Provincialization Act
Yeah.
2017.
You say since
And avail
non-availability of record is a
Record.
as the provincialization took place long years back, and as the petitioners are not applying, we cannot
As-
provincialize, correct?
Yes, Your
Lordship,
Lordship, as per the Act also, Your Lordship, the petitioner has to apply it, Your Lordship, for provincialization.
Lordship will kindly see our affidavit, Your Lordship, additional affidavit.
1 minute. Did you respond to the advertisement of 6/11/2004?
Yes, Your Lordship. Yes, Your Lordship. We have filed an additional affidavit, Your Lordship, in a pursuance of order dated 14/11/22. In that, we have given the representation, annexure 1, 2, and 3, page number 34 to 36, Your Lordship.
1 minute, 1 minute.
Page 34 to 36 of our additional affidavit.
Which?
34. 34.
Your additional affidavit.
Yes, Your Lordship. 34 is our application to the Director of Secondary Education. The Inspector of School, in fact, forwarded our application to the Director of Secondary Education. Page 34. Page 35 is another application forwarded to the Director of Secondary Education by the Inspector of School. And page 36 also another application. It is forwarded to the Director of Secondary Education by the Inspector of School.
See, in this judgment passed by this court,
Yes, Your Lord.
the certain procedures that were followed.
Yes, Your Lord.
The government reconstituted the committee. Government issued an advertisement calling for all the drop teachers to make the application.
Yes, Your Lord.
After they constituted the committee, then those dropped teachers, they were made into 3 categories: list 1, list 2, list 3.
Yes, sir.
Under which list you come?
Lordship, that is not made known to us, Your Lordship. We have
How can you claim parity with these 3 petitioners?
because our applications are forwarded
This
to the
is why
respondent.
this court asks you whether you've made your application to the advertisement of 6/11/2004.
Yes, Your Lordship.
Where's that application?
We have given these disclosures in our additional affidavit, Your Lordship. Paragraph 4, Your Lordship. The deponent begs to state that on 14/11, the Honorable Court was pleased to pass an order directing the petitioners to apprise the Honorable Court regarding the fact as to whether the petitioners have submitted their applications in response to the advertisement published by the Education Department.
To Director, fine.
But we have annexed those, Director of Secondary Education. Additional affidavit, sir. Okay. This is the additional affidavit.
Whether it is received or not.
Yes, on the last occasion. Correct. আগতে তো দিয়েছে last occasion তো দিয়েছে।
Address to the director.
The inspector put to the Director of Secondary.
Is the High Power Committee still in existence?
Yes.
High Power Committee is still existing.
Okay. And how about the advertisement 1 to 2012 and 4 to 2012? Did you make your application?
Yes, Your Lordship.
Both.
Both, Your Lordship.
So in both these 3 advertisements, you made your application.
Yes, Your Lordship.
Then where's your name in the wish list 1, 2, or 3?
That is not made known to us, Your Lordship. Lordship will kindly see this annexer A of our additional affidavit, Your Lordship, page 34.
No, that I've seen. That
Yeah.
I've seen.
The inspector of school has forwarded our names to the director of secondary education after
No,
receiving
in
our
split
application.
petitioners, their names appeared in the list number 3.
Okay.
And on that basis, this court gave this direction. Now we want to know under which list your name comes.
That, Your Lordship, they will be able to.
You give her a copy of this judgment.
Last occasion, I have already furnished to SM in the SMT 16.
Just see whether in which category the list names of the petitioners come into. Either list 1, 2, 3. Because a committee was constituted after the advertisement, and then all these teachers dropped illegal. They were made into 3 groups: 1, 2, 3. All right. Okay, Hurt
I
MS.
need to
F. Hussain.
Your
F.
Lordship,
Hussain.
regarding this
Hussain.
additional affidavit, Your Lordship, what they are submitting, Your Lordship, I need to take a verification whether later
Then as counsel for the petitioner, and as
received or not.
regards, then the standing counsel, secondary education department, prays for some time to receive instructions with regard to the statements made by the petitioners in their affidavit. Then reply. Correct.
Additional affidavit.
In the additional affidavit dated 7/2/2023. Stop. List. Praise a lot. List after 2 weeks.
Lordship, if a date can be fixed, Your Lordship.
Fixing a date after
And
vacation. Very
pending
difficult.
matter, Your Lordship, 22.
Okay. 24th January.
Deeply obliged, Your Lordship.
Deeply obliged. Yes.
Item 50, ordered.
Lordship, we have filed an interlocutor application, Lordship,
Where's that application?
along with the repetition.
What is this?
Lordship, the similar issue Lordship has already decided. Lordship, this is with regard to the Lordship 10-year cap, which is not applicable to us. With regard to Lordship MBBS examination, Lordship. Lordship, we are not allowed to appear in the 7th semester. Thereafter, we have filed.
NMC, my learned friend is appearing.
Yeah. There's an interim order, Lordship. On the basis of the interim order, we are allowed, but the results have not been declared. And now, Lordship, the next examination is scheduled to be held on 4th of January. And the form fill-up is on?
Yesterday was the
Yes,
last day.
yesterday was the last day, Lordship. In my interlocutory application, Lordship, I have annexed, Lordship, I am just praying for page 44, Lordship, page 44. Page 44, Lordship has already decided the same issue. And in terms of your losses, other losses subsequently, similar repetitions have already been disposed of.
This order may be passed, my lord, when the instruction from NMC is received. As of now, my lord, let him appear, my lord. There is an exam, my lord, in January 2025 as an interim measure. And my lord, so far as the result part is concerned, my lord, I have got the instruction. If Lordship allows, we will publish it and we will give him the result. But I have got it in instruction.
No.
Petitioner's name is Khurshid Alam Chaudhary. But you will see the name, my lord, in the chart. Khurshid Alam Chaudhary.
Who's the petitioner?
Khurshid Alam.
Khurshid Alam Chaudhary.
In the very first page, the my lord instruction is there.
Okay.
third semester he has appeared, pursuant to some interim order given by his honorable court, and he couldn't succeed. So let him appear on 4-1. Then, my lord, NMC tomorrow, if NMC says, my lord, that yes.
Page 36 is the lordship notice. And the exam schedule is on page 37.
13 times. 13 times. Probably 12 or 13 times he'll be okay.
No, third time. I have cleared all the examination except the 7th semester. I have cleared all the examinations. 7th and 9th. 7th and 9th semester.
13 years. Almost 13 years.
So there is no cap.
No cap. Well, let him appear, my lord. If he succeeds, lordship will pass a final order.
The notice is at page 36 and look the examination.
No, you are referring to the IA?
Aye.
Page?
Page 36, notice. And lots of the examination schedule is at page 37.
Yeah, to the third semester,
For the supplementary and failed students.
Supplementary or
Failed students.
नहीं यार
Lordship will see page 31, my lord. Similar order may be passed by page 31. The lordship order is there.
Which
Page-
one? In the IA?
In the IA, page 31. This is order dated 28 to 24. 28 to 24, my lord, page 30.
No, that was in the main petition.
Main petition.
In the IA, he wants that he should be again
No,
given
that's
a
why I'm
chance
saying,
to
my lord,
talk.
that order is very clear, my lord. Same order may be passed, my lord, for appearing in exam. Page 31 of the IA. Last page.
But your lordship in page number 44, your lordship has passed an order.
Okay. Heard, Mr. S.K. Das, learned counsel for the applicant. Also heard Mr. B. Gogoi, learned standing also health department for the opposite parties.
But here, 1, 2, 3, 4, and 5. Yes. 1 to 5.
1, 2, 3, 4, and 5. And Mr. K. Gogoi, learned standing counsel.
As a council for NMC law.
Standing counsel.
Not as a council.
Learned counsel appearing for the NMC for the respondent number 6. Correct? Stop. Para. The applicant as writ petitioner preferred WBC number 7304/2023. Challenging the, who is that order passed by this court? Challenging the
Notice lordship dated 8/6/2020.
notice dated 8/6/2023 issued by the principal of Guwahati Medical College,
Right.
by which the applicant or petitioner was debarred from appearing in the third professional part 1 MBBS examination to be held in the month of March 2024. Stop. This court, by order dated 28/2/2024 in WBC 7304 of 2023, by way of an interim order. Directed the respondent authorities to allow the applicant of the petitioner to appear in the third professional part 1 MBBS examination to be held in the month of March 2024. It was also provided that the petitioner shall submit his application form for the 7th semester in the Guwahati Medical College, and the same shall be accepted and processed. Stop. The permission to appear in the examination stated to be held in the month of March 2024 was, however, made subject to the outcome oblique final determination of WBC 7304 of 2023. Stop. This is still pending, isn't it?
Pending also.
During the pendency of the aforesaid writ petition, comma, the opposite party number 3, oblique principal cum chief superintendent, comma, Guwahati Medical College and Hospital, Bhangagar, issued a notice on 26/11/2024 directing the students to submit their forms along with fees for the MBBS third professional part 1 examination scheduled to be held from 4/1/2025. Stop.
Lordship may indicate for a supplementary and fail student.
Is it?
Lordship.
Yes, there is a, in the bracket it
In
is
the
mentioned.
bracket.
Where's that? Where's that?
Page
Page
36.
36, Lordship. Page 36. Page 36, fourth line, Lordship. Full in bracket.
Page 36.
First paragraph, fourth line, Lordship.
Okay. For the within bracket, huh? For the supplementary oblique failed students.
Lordship.
Stop. The petitioner, by way of the present interlocutory application, is praying for direction from this court to permit the petition, the applicant, the applicant oblique petitioner from this court to permit the petitioner or the applicant oblique petitioner to appear in the third professional MBBS within bracket part 1 supplementary examination, is it?
Yes.
Supplementary examination within bracket for supplementary oblique failed subjects, which is scheduled to commence from 4th of January 2025. Stop. Para. Considering that this court had already permitted the petitioner to appear in the third provisional part 1 MBBS examination, which was held in March 2024.
And my results I have placed, madam.
And as Mr. B. Gogoi, London Standing Council Health Department, has also placed the result of the petitioner by way of a communication dated 23/4/2024.
Lordship will permit us to
Declare the results.
declare the result. That will be more convenient.
No,
It
no,
will
no.
be there in the record.
Don't say like that, huh? Cancel the whole line. Mr. B. Gogoi, London Standing Council Health Department, has also produced a communication written by the registrar Srimanda Shangardev University of Health Sciences, dated 23/4/2024, wherein request has been made for publication of the result of the petitioner. Stop. after considering the communication dated 23/4/2024, the which authority?
The university, madam.
The
University.
concerned university is permitted to declare the results of the petitioner, which was held in the month of March 2024. Stop. Para. Can I say that he has failed?
Result will may not speak, madam. Let's not
Okay,
let down.
okay. Considering the fact that this court had earlier allowed the petitioner,
Yes.
applicant of the petitioner to appear in the MPBS third professional part 1 examination.
Lordship will may not mention the result because that's why he is aware of that and that's why he want to participate in the press conference.
Cancel that line. The communication further indicates that the petitioner has failed in all the appeared subjects. Stop. Para. Considering the communication dated 23/4/2024, the authorities are directed to permit the petitioner or the applicant oblique petitioner to have you submitted your form?
Unless they give us the mark sheet, we cannot fill the form. They may be clear to-
Okay. Then what is it? The authorities are directed to publish the results of the petitioner
Within a period of 7 days, madam.
within the period of 7 days, and thereafter permit the petitioner to submit his form
Right.
for the MBBS MBBS third provisional within bracket part 1 supplementary examination within bracket for supplementary oblique failed students, which is scheduled to be held from 4th January 2025, and also permit the petitioner to appear in the set examination. Stop. With we can close this, IA?
Yes, yes, we can be closed.
Above directions, IA stands closed. What is there in the writ petition? What do you want?
In case my lord says directed last occasion to obtain instruction the NMC lordship, Medical Council of India lordship. After
Lordship will proceed after 4 weeks.
Lordship will proceed
In the
after
meantime,
4
the
weeks.
exam will be over.
Mr.
let them
S.K.
file their
Das,
affidavit.
Learned Counsel for the petitioner,
First or second week of February.
as well as K. Gogoi, Learned Standing Counsel,
My lord may indicate as a council.
Learned Counsel appearing for the NMC, and Mr. B. Gogoi, Learned Standing Counsel, Health Department. List the matter after 4 weeks.
Lordship, lordship.
But for my instruction, I can retain.
Huh?
By written instruction, I can retain it.
I think
Or
some,
yes.
if he has
Let
made
it
some
be
mistake,
there.
what you can do,
Let it be part of the record. Then tomorrow is required. my lord.
okay, the communication that is transferred is placed on record.
Lord.
May I please, Lord?
Yeah.
Item 52, Lord.
Huh.
My lord, it's contempt matter, my lord, this assistant professor, my lord, all the time she is crying, my lord, that affidavit has not been filed by the respondents, my lord. And the honorable court's order was to come to the conclusion of this entire fact, my lord, within a period of 1 month. Now it is almost
Lordship,
1
the
year,
matter
my lord.
has already been complied with. We were directed to give the maximum marks were given to him for his
And that's
experience,
why
lordship.
already been
That speaking order
selected
has already been passed,
my lord,
lordship. So the matter has already been complied with. Lordship may look at the second last paragraph.
conclusion
May I
has to
read?
come, my lord. I have been already recommended by the selection committee, my lord. There is a order, my lord.
Lordship may have.
This order has already been placed before this court, and court said that you file an affidavit. How you can say now all these things, my lord? Last time also he produced this, my lord. Lordship, kindly have a look, my lord, the honorable court's order. Once I have been found to be number 1, it has been selected, my lord. I have to be appointed. And these provisions clearly say,
you have produced this on the last occasion.
Yes, Lordship, the
Yes.
direction was, is
You
at,
file your affidavit, that's what.
yes,
this-
Lordship, but the direction is at page 17, Lordship.
Yeah, that I've seen.
Yes, Lordship, so he was given the maximum mark for
that,
experience.
Hold on. My lord, already my case has been recommended by the selection committee, my lord, to the director, my lord. Now director has to come to the conclusion of this in terms of the honorable court's order by passing the order as per the rules.
That's why the speaking order was issued.
No, speaking order, simply speaking order, there is no
You
conclusion.
challenge the speaking order.
Then you file your affidavit.
Yes, Lordship.
then
Yes, Lordship. We'll file that.
I'll give you a week's time.
Yes, Lordship.
Heard Mr. B. Chetril and counsel for the petitioner, Mr.
D. Upamanda.
D. Upamanya and counsel appearing for respondent number 5 is allowed a week's time to file affidavit.
Lordship will fix the date, otherwise matter will go on, my lord. So,
At least after 1 week. After vacation, I can't fix.
Lordship,
it.
Lordship,
If you
after
can, you can
vacation.
make your principle.
After vacation, Lordship.
Item number 55 and 56, my lord.
Yeah.
Highly
Did it come in the order certificate follow, my lord? Because IA is there. I have filed the IA. What's the
For what?
certification? It's the alteration of the order 1924. Did it come on order certificate follow? After vacation. After
Lordship,
the vacation, my lord.
in these matters, Lordship, state respondents were supposed to file affidavit. Till now, they have not filed affidavit. That will be necessary for consideration of the IA and read petition both, Lordship.
Let it come on order certificate in follow.
Okay, I'll list the matter after the winter vacation. On that day when it's listed, you can get it updated. That is better.
After the vacation, my lord.
After, we-
Any date may be
after winter vacation, I'm
because there is urgency, my lord.
you can make your mention.
My lord. Obliged.